Hello, everyone, and welcome to Uncivil Law, where, as always, we learn through the misfortunes of others. As always, I'm your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the U.S. Supreme Court, and I hope you're having a great day. For today's coverage, we turn again once to the Jennifer Crumbley trial. Jennifer Crumbley is on trial for involuntary manslaughter related to the school shooting committed by her son, Ethan Crumbley. The underlying idea being that she was aware of a threat that existed, recklessly disregarded that threat, which caused the death of another. This is a novel cause of action. We're still in the state's case in chief, although we expect that case to be resolved today. We turn our attention to the case already in progress, and we will see how things go today. So let's go ahead and get started with that.
Could you raise your right hand? Please step up to that.
I do, Your Honor.
All right, please step up, have a seat, and then would you please state your name for the record?
Timothy Willis, TimothyWillis.
Go ahead, prosecutor.
Thank you, Judge. I just need to make sure this is connected.
Is this on, Judge?
What's that?
Is this on?
That usually is last. That usually is on last. So
Thank you.
It's all in a second.
Is the screen on, sir?
Yes.
Yeah, it's the last thing that goes on usually.
May I proceed, Judge?
Go ahead.
Sir, how are you employed?
I'm a detective lieutenant with the Oakland County Sheriff's Office.
What is a detective lieutenant?
My duties include, I'm one of two detective lieutenants in the Investigative Forensic Services Division. We offer support services through investigations to our agency and really law enforcement in the region. My duties include the Special Investigations Unit. I'm in charge of that. I'm in charge of the Fugitive Apprehension Team. I'm in charge of the Computer Crimes Unit, and I'm in charge of the Warrants Unit.
Okay. And we've heard about the Special Investigative Unit through Sergeant Joseph Bryan. Does that individual work for you as well?
He does.
Okay, so specifically, the Special Investigative Unit, can you tell the jury what they do?
So the Special Investigations Unit handles major crimes for our agency. We often get requests from other agencies to assist with their crimes or handle them. These crimes range from high-profile cases, political cases, whatever really they kind of request. Our training is pretty expansive in as much that we handle like larger, complex cases.
Okay. And how long have you been a lieutenant?
Since 2016.
Okay. And all told, how long have you been a police officer?
I hired in 1996, so I'm approaching 28 years.
All right. Sir, I'd like to direct your attention to November the 30th, 2021. Do you recall that day?
I do.
Were you notified of an active shooter situation at the Oxford High School?
I was actually at the prosecutor's office discussing another totally separate matter, and the prosecutor and her chief assistant came in and advised me, was I aware that there was a shooting at the Oxford High School, and I was not at the time.
Okay, so you were meeting on a different case completely?
Yes.
Okay. And do you recall approximately the time that occurred?
It was around, understand it was a very difficult time to remember exactly, but it was around 1 o'clock.
Okay. And what did you do when you were notified?
Prior to that, we had recently had a similar, but it was a false alarm incident at a different school. So my initial thought was this was another one of those, just someone pulled an alarm or something happened. I immediately collected my things. I got up and walked. I made a phone call. For the life of me, I've been trying to remember who I called. I cannot remember. I do remember them telling me it's real.
Okay. And when you were told it's real, what clicked in with you?
I went downstairs.
Okay.
Excuse me.
Take your time.
went downstairs and immediately got in my car and went lights and sirens to the scene.
Okay. When you say lights and sirens, what does that mean?
My vehicle is an undercover vehicle for all intents and purposes, but it is equipped with lights and sirens to respond to different things. So, police term, we call it coding. It's you know, just like when you see cops racing to the scenes, it was very similar to that, except my car is an undercover type vehicle.
Do you recall how long it took you to get there?
It was somewhere within 20 minutes, I believe it was.
Okay. Do you remember the drive at all?
I remember portions of the drive to the scene. If you're familiar with the area, M24, Lapeer Road is the major route that we took to get there. It's the major road to get there, and it was completely lights, sirens, cars, just flooding northbound on Lapeer Road, and it was chaos.
Sir, I'm going to show you what's already been admitted as People's 5. This is a map of the Oxford High School. Can you see that on your screen?
I can, sir.
Okay. Can you tell me what you observed when you first arrived at the school?
I observed when I came, there was students leaving the school. There was police officers flooding into the school. Emergency first responders. I know some of our people came right from their home address. It was I remember being shocked at, I live in a neighboring community, and I was just shocked that we have that amount of resources in a northern Oakland County school that quickly. Because, I really moved to get there. By the time I was there, people were just flooding that place.
Do you recall where you went? First of all, let me ask you this. Did you go inside the school?
I did.
Okay, when you went inside the school, what was the situation?
I have no recollection of where I parked exactly, but I know I went in through the front office area. You can see on right there where it says office.
Okay.
That entrance on the south there.
So this would be the main entrance to the school?
Yes.
Okay.
Captain Todd Hill, he was then a lieutenant, had already set up an incident command post, an interior post. Understand, we had a perimeter all secured. We were securing all the doors, no one in and out unless you were law enforcement or emergency first responders. And we set up, because it was so cold that day, it wasn't ideal. However, the area where we were at, we determined to be relatively safe. So all of us responded to that area to start handing out our assignments. We refer to that as the interior command.
Okay, so you said incident command, interior command. Tell us the difference.
I'm sorry. So the interior command is just the location on the interior. Incident command is where most, if not all, the decisions are made. So at the time, the incident commander, Captain Hill, his focus was casualties, safety and security of the building, and searching for additional shooters. When I was driving to the scene, I do recall them saying, we were getting tips from, imagine being a civilian, or, driving around and seeing cars fly by you, hearing about a shooting. We got tips just flooded into our 911 center about, I think the shooter's in this car. I think the shooter's in this car. There's a man in a camouflage jacket running through the gravel pit. We think that's a shooter. So it was just, all we knew to do was go to the school first. We had no idea what else, if anything, was going on. So the exterior command was set up to, first to protect the school. The interior command was set up to handle the issues going on within the school that
also in charge of the special investigative unit?
Yes, sir.
You said Lieutenant, now Captain Hill was focused on the active scene. So
Yes, sir.
clearing and casualties, things like that? Okay, what was your focus then?
So immediately upon entering the thing, I had a brief conversation with Captain Hill, advised that I would be handling the investigative portion of this. And we started then devising a plan, the best way that I could participate in the active investigation while the other stuff was going on. There was so many tips, if you will, social media tips coming in about this, that, and the other that, you know, a lot of them certainly proved not to be true, but they had to be vetted. So, you know, I could not just go in and start investigating the scene. There was several opportunities, i.e. For us to interview. We heard victims were at hospitals that needed to be interviewed. There was obviously tons of staff, personnel, and students still on the scene that we wanted to talk to and discuss and try to figure out what had happened.
Okay, so would it be fair to say that it was your responsibility to coordinate this investigative effort?
Yes, sir. So my job, that's exactly what my job is. My job is to direct those resources to the follow-up investigation.
Would it be fair to say that you are the officer in charge of this case?
Yes, that's fair to say.
Tell the jury, please, what does it mean to be an officer in charge?
So, as I stated earlier, I direct the investigation, meaning identify and attempt to interview or have my team attempt to interview victims, witnesses. I decide, I assist. You saw Bob Catellis up here from the crime lab. Him and I worked together about obtaining what evidence we deemed was going to be necessary for this case. I direct officers, you know, to secure I directed the officers to secure the Crumbley home because we learned where the shooter lived. At the end of that, I comprised the information, and then I turn it over to the prosecutor's office, and then we discuss charging decisions.
Okay. And that's what an officer in charge does in every investigation.
That's right. This investigation was not unique to that. We do them with all of ours.
Okay. Now, it's fair to say that there was a massive amount of evidence uncovered in this case.
Yes. Imagine we estimated approximately 1,700 people in the school that day. They weren't using their lockers. There was backpacks, cell phones, you know, just dropped in. Obviously, you know, they were worried about their safety. So we just had a lot of evidence within the school, not counting, you know, evidence at different hospitals from victims, the shooter's home, things of that nature.
Okay. Judge, may I approach the witness?
Sure.
This is Exhibit 1. We had a stipulation.
Yes. Your Honor, we would stipulate to exhibits 1 through 4.
1 through 4.
1 through 4, thank you.
1 through 4 admitted.
Sir, I'll just give you all these right here.
Okay.
One is on top.
Yep.
Can you tell me, please, what I've just handed you?
These are the autopsy protocols for the 4 deceased victims.
I just want to make sure that's all. Okay, thank you.
Sir, tell us, you've reviewed the autopsy protocol in this case?
Yes, sir.
Do you know the identities of the victims?
All right, let's just do a little volume test to see how I compare to the court audio. So how's that working out?
I'm gonna show
It's
you
a
what's
little hard.
stipulated
One of the
for
disadvantages in
413.
StreamYard or its competitors is I can't really hear the bounce levels,
How
so
old was she when she was killed?
it's challenging.
14.
And sir, can you tell us, please, how she was killed?
You're louder than the court? Well, that's good. Am I a lot louder? Is it massively louder? Is it unhappily louder? Ridiculously louder? Okay. All right, let me tone it down.
In her upper torso, her abdomen. her
This is how we
thighs.
do things the hard way, people. Welcome to streaming. All right, let's see. Let's turn this down to about 60%.
Exhibit 2.
I'm sorry, and her left forearm.
All right, how's that? Is that better? Worse? Still needs to go lower? Too much, too little? Are we happy with this? Do we need more? Still more? You don't notice any difference. Well, that's disturbing. All right. Well, we'll wait till they're talking.
Referring to exhibit.
All right. How about now? Is that working?
Lieutenant, can you tell me if you need, did I promote or didn't promote you, Lieutenant? Can you tell me if you need a break?
Yes, yeah, I'm
Okay,
sorry.
just let me know, okay?
Yep, thank
You
you.
want to go? You want to go 50%?
No, this is people's 419 on the screen.
We could go to 50%. See if that
Also
works.
referring to-
Let's go to
it's been
50%.
stipulated to.
Let's try
Also
50%. See how that
referring
works.
to Exhibit 2, autopsy protocol
All
for
right.
Madison Baldwin. Sir, how old was she when she was killed on November the 30th?
17 years
50%
old.
works. Great. We'll stay at 50%. Fantastic.
Again, cause and manner of death was gunshot wound to the head. Manner of death was homicide. She
I can't bring the
It was
court
a close
up. All I can do
contact.
is change my volume.
shot, meaning the
The court is as loud as it's going to get.
firearm was either on or near the victim's head when the trigger was pulled.
Referring now to Exhibit 3. That's an autopsy protocol for Justin Schilling, is that right?
I think I have Tate Mears 3,
Okay,
Justin
I'm
Schilling's
sorry.
4.
Thank you, St. Mir. And how old was he when he was killed?
Tate Mears was 16 years old.
This is Exhibit 420, it's been stipulated to. Tell us please how Tate was killed.
Again, the cause and manner of death from the autopsy protocol was gunshot wound. Tate had multiple gunshot wounds. Manner of death was homicide. Tate was shot in the back of the head at a further distance.
Now Exhibit 4, sir. And that's the autopsy protocol for Justin Schilling.
Yes.
I'm showing you what's been admitted, stipulated to for admission is People's Exhibit 421. Sir, is that Justin Schilling?
It is
How old was he when he was killed?
17 years old.
Tell the jury, please, how he died.
Justin Schilling, you'll see, well, you won't observe it, but he was, cause and manner of death from the autopsy protocol was gunshot wound to the head, homicide. He was also shot at close contact to the back of the head.
Sir, were others wounded and suffered gunshot wounds as well inside the school?
Yes,
Do you know their names?
I do.
Can you tell us who they are, please?
There's Phoebe Arthur, Elijah Mueller, Kylie Osage, Riley Franz, John Asciutto, Aiden Watson, and Molly Darnell, who testified earlier.
Thank you, sir. Sir, tell us what happens when you assume, may I approach?
Sure.
I'll take those, sir.
Thank you.
Tell us what happened after you assumed the lead of the investigation. So where were you when this happened, and tell us the first thing that you did.
So the first thing I did was collect myself because I was pretty overwhelmed, and then we were determining areas of the school were had searched, and we were getting kids to the reunification point, which is I think was testified to at the Meyer. As that was happening, I made an announcement that I was handling the investigation to the 100+ emergency first responders that were in that office area that we saw earlier. And I said, if you're an investigator, come see me. And in hindsight, I don't know if it was the most efficient way of doing business because 100 investigators started walking toward me. I'd never obviously dealt with anything like that before, but partners from the ATF is where I met Special Agent Brandon, partners from the FBI, local law enforcement from all over the region, all offering help.
Okay, so was it your responsibility at that point to direct certain officers and agencies to do certain aspects of this investigation?
That's correct. They, for instance, Special Agent Brandon approached me with his partner, I believe, and said, do you have the registered owner of the murder weapon? And I said, at this point, no, I did not. He's like, I'll take, let me take some information off the gun. We'll handle that. We'll track that down for you. And he did that, and I saw him, or I heard from him a short time later, where he advised the gun was registered to James Crumbley.
Okay. And you discovered that weapon was purchased on November the 26th, 2021 by Mr. Crumbley?
That's right. Just a few days prior on the Black Friday before.
Now, while you were on scene, did you come to learn the identity of the shooter?
I did.
And then was a decision made to secure the Crumbley family home?
It was. The shooter was on his way to the Oxford substation. I directed a couple of my investigators, Sergeant Joe Bryan, who you saw, to attempt to interview him at the substation. In addition, now that we knew who the shooter was, I directed detectives from the Pontiac substation. Lieutenant Marsban kind of spearheaded that part, and to go to the shooter's home to look for any additional casualties. It's not uncommon in a shooting situation where the shooter starts in the home and then goes to the school. So I was concerned about that initially.
In a school shooting situation?
That's correct.
Okay, and you had learned about that in your training?
Yeah, and just by prior school shootings.
Okay.
It's certainly not uncommon for that to happen.
And so you sent officers to that location, 112 East in Oxford?
I did.
All right. Now, at that time, was there a concern of explosives?
Yes. So, again, understand everything's happened very, very quickly. People started doing open source searches on the
Thank you, John Boy, for upgrading your membership. We do appreciate everyone who supports our channel. It's very, very appreciated. Thank you.
Finding different things, and the internet is a very expansive place, as we all know. And there came a video from YouTube of him deploying a Molotov cocktail, which is essentially an accelerant in a bottle with some sort of
Wick.
ignition device, wick, if you will.
Thank you.
Throw it, and when you throw it, it blows up, spreads, because the fuel inside it kind of spreads. So there's a YouTube video of that. There was also, and I'm sure we'll get to it, there was also a journal with written passages in it that described secondary devices, meaning, there was a concern, and again, at this point, I went back to Captain Hill and advised him, hey, look, there's a concern that there may be secondary devices in and around the school.
Okay. So when that information became known to you as lead investigator, what steps happened next?
So Captain Hill contacted the Michigan State Police bomb squad. While that was happening, I wasn't present for this, but it's my understanding a canine from the sheriff's office alerted, an explosives canine alerted on the backpack that was found in the bathroom the shooter exited prior to the shooting. So
what does that mean, an alert?
So the alert means that the dog detected some sort of explosive. Now, it could be a legitimate explosive, it could be a firearm, it could be ammunition, it could be something of that.
Okay. So what was done to alleviate this threat?
So, as I stated, Captain Hill called for the Michigan State Police bomb squad. They went in with a robot, and I have no expertise on how that works, but they determined that the bag was safe.
Okay. Now, sir, you were obviously on the scene at the school on November the 30th, 2021,
I was.
and you became aware that the Oxford High School has a number of security cameras.
That's correct.
Okay. And as officer in charge of the investigation, did you also interview witnesses or review witness statements?
I did.
Okay. Now, as a result of that, did you learn the path the shooter took on November the 30th, 2021?
Yes, sir.
So, can you tell us in what hallway and outside what room the shooting started?
Yeah, from the map earlier, you saw the highlighted area. That's all commonly referred to in Oxford as the 200 hallway. There's a short hallway and then a longer hallway. The shooter exited the bathroom adjacent to room 258, and that's when the shooting began.
And I'm going to show you what's already been admitted as People's 12. What are we looking at here?
So this is the backpack that the shooter was carried into the bathroom. That was examined for explosives that we found on the scene.
And what else do we see in this picture?
So you can see that there's some personal effects. There's charging cables. There's a journal. There's a book.
Okay. When you reference journal, this is what we're talking about?
That's correct.
Okay. Now, what of note was discovered on those pages of paper? Not in the journal, but the other pages.
Yeah, so there was over 90 loose leaf papers you can see right there. They're different assignments or whatever. And can't hold me to it. Over 50 were had drawings of firearms on them.
Now, sir, did you have the opportunity to review that handwritten journal that's depicted in People's 12?
Yes, sir, I did.
Okay. Describe what that journal is.
So the contents, sir, or describe the journal?
Both.
So the journal was a hardbound leather type journal. Should be in there. You might be able to cut it open there. It was there was approximately 22 pages of written information in the journal. It appears from some of the dates that it was written from the back cover to the front. The earlier dates seem to be on the back side, if that makes sense to you. Like I said, it was about 22 pages total in length.
Judge, I'm going to mark this for demonstrative purposes only as exhibits, so the record's clear. I believe that's 428, again for demonstrative purposes.
I'm sorry, may I please take a look at it?
Yes.
Is that just the?
It's just the hard copy journal.
Okay, thank you.
Yeah. Thank you.
So that black notebook you're holding in your hand, that's what's depicted here in Exhibit 12 that I'm magnifying.
That's correct.
Okay. Now these papers that we just talked about, we said over 50 with different pictures of weapons. There's no evidence that was ever turned into the school, is that correct?
Yes, I have no evidence of that.
Okay. And you've had the opportunity to read the entire journal?
I have
Okay. Out of that notebook, how many pieces of paper have actual writing on it?
22.
Okay. And does one of those 22 pages include just a drawing and a quote from a book?
Yes.
Okay. Now, out of the remaining 21, how many reference the school shooting?
Every single one.
So there are some that have been admitted, some portions of that. I'm going to go through those with you. Just so you're aware, we've numbered them to keep them straight for you as well as the jury. Number 1 is the drawing, page number 1. Page 22 would be the back cover of that journal. Is that clear?
Yes.
Okay, and the back cover of the journal has actual writing on it as well.
Yes.
Okay.
I'm sorry,
This is
it's
exhibit.
401.
Yes. 401.
Are you gonna go through,
Only the ones that have been admitted.
I understand, 401.
They're all 401.
Oh, they're all 401, I
Correct.
see, thank you.
Correct.
You said individually, so I got confused.
Okay. So this has been admitted as page 401. Sir, in reading the journal, were there passages in there indicative of a request for mental health help?
Yes.
Can you read what's been identified here as page 6 of that journal?
Yes. The shooter writes, "I have zero help, as you can see on hold, for my mental problems, and it's causing me to shoot up the fucking school."
I'm going to move on to page 5. Could you read this passage, please?
In this one, the shooter writes, "I want help, but my parents don't listen to me, and I can't get any help."
Now, this is page 19.
I'm actually slightly curious why we're not objecting on hearsay grounds at this point, to be honest. Because it's not the shooter himself on trial, in which case it would be statements against interest party opponent. So I'm not sure why we're not objecting on hearsay grounds. Okay, I'm confused slightly, but then again, it's early, I'm tired, I can't think straight. Maybe I'm missing something. Yeah, why is this allowed? I'm slightly confused. I don't know.
Can you read that?
Yes. Shooter writes, "My parents won't listen to me about help or therapist."
Sir, in that journal, were there entries about the shooter's desire to obtain a 9mm handgun?
Yes.
This is also Exhibit 401, page 22. Could you read those quotes, please?
Yes. The shooter writes, "I want to shoot up the fucking school."
I mean, unless they have independent proof to know for sure that the parents read it, then it would be a hearsay exception because it doesn't matter if it's true, it would go to the effect of the mind of the listener. But without proof the parents read it, I'm still confused. Yeah. Yeah, I don't understand this. I don't get it. I'm confused. This goes to show Ethan's mental state, but how it goes to show the mom's mental state is unclear. I'm so confused.
School so badly. Soon, I'm going to buy a 9mm pistol.
Sir, were there any passages regarding the shooter's plan for the actual shooting?
Yes, there were.
Okay. Here's page 3, also Exhibit 401. Could you read that, please?
Yes. Shooter writes, "I'm about to shoot up the school and spend the rest of my life in prison."
Were there any journal entries about the shooter's access to the 9mm handgun?
There were.
This is also Exhibit 401, also page 3. Could you read that, please?
Yes, sir. The shooter writes, "First off, I got my gun. It's a SP 2022 Sig Sauer 9mm. Second, the shooting is tomorrow. I have access to the gun and the ammo. I am fully committed to this now. So yeah, I'm going to prison for life, and many people have about 1 day left to live."
Thank you, sir. Now, is the journal written in normal size fonts, or are there certain passages that are bolded and larger than normal size font?
Both.
Okay. And were there drawings in there as well?
There were drawings.
Okay. Were the drawings small or were they large?
Yeah, there were large drawings.
Okay. What's an example of a large drawing?
Yeah, so there was a large drawing in the journal of a firearm being pointed at the back of a presumably a woman's head. There was a drawing depicting a 9mm caliber round versus a .22 caliber round. Those types of pictures were found in the journal.
Okay. And on the cover of the journal, what does that say? The actual cover of the journal itself?
It says apartments.com.
Okay. Superintendent, you said you've seen the Oxford High School security footage that depicts the actual shooting.
Yes, sir.
Judge, we're going to introduce that now. This is Exhibit 402. It's been admitted. I would like, if the court could instruct the media not to play that.
Yes, the media has agreed, and I'm going to request that the media not play, show the video in the school. That's surveillance footage of November 30th, 2021, and is People's Exhibit 402.
402, thank you.
And the victims who are present are aware of the content of this specific video.
Yes, Judge.
Go ahead.
Before we get
Yeah.
started, tell us please what this view depicts, what hallway?
Okay, so if you can recall back to the highlighted areas of the school map, this is that short hallway. The shorter portion of the long, it's all of the 200 hallway, but it's the shorter portion of the entire.
Can I stop you for a second? Are you okay if the audio is on still?
There's no audio.
Well,
Oh, is audio?
there's streaming in the courtroom, and there might be audio from the news camera, so I just want to make sure that there's no objection.
That's fine. There's no audio of the video. Is what I
Okay,
meant.
right, okay.
Okay, so this is the short portion of the 200 hallway?
Yes, and the bathroom that you see right there by the drinking fountains is the
Thank you,
one-
Monet, for 23 months of membership. We do appreciate all of our uncivilians. Thank you so very much for your continued support.
That's where that backpack was found?
Yes, sir.
Okay, so this doorway here would be the doorway to classroom 258?
That is 258 there, yes.
Okay. And just so the record is clear, this video begins at, it's 12:46 p.m.
Yes,
and the actual shooting began at 12:51.
51.
Okay.
Correct.
I'm going to play right now. Again, this is 12:46. Tell me if and when you see the shooter walking down the hallway.
Okay. He is behind the young lady in the red sweatshirt right there. He's about, with the mask on, the black shirt, and the gray sweatshirt.
Okay. And that's with his backpack over his shoulders?
That's right. Yes, sir. And he's going to make a right turn into the bathroom here.
So we have a split screen at this point, and that's
That's just a camera angle from the other hall, or from the same hall facing the other way.
Okay. Okay. I'm stopping at 41 seconds. Identify who you see in this video.
So that's the shooter. If you want to, the two. That's Phoebe. On the left there is Phoebe Arthur. To the right is Elijah Mueller.
Okay.
This is John Asciutto. So these four young ladies here in the Carhartt or the brown jacket is Kylie Osage. Directly across from her is Hannah St. Juliana. This is Riley Franz in the pink backpack, and across from her is her sister Bella Franz.
Okay.
At the very end, you can see the beginning. That's Madison Baldwin walking up the hallway.
And this is at 12:51 and 12 seconds on November the 30th?
That's correct.
They're just not showing the video because it's too graphic. So they don't want to stream the video. I mean, obviously everyone in the court can see it. The jury can see it. They just don't want to show the video because they think it's too graphic or depicts minors or any other number of reasons. And I have no particular problem with that. Yeah. So there is video playing. The video just has no audio. So they're watching some closed circuit feed from the school. It has no audio. So we can't see it and there's nothing to hear. So I continue to wonder about the admissibility of the journal with respect to the mother, though. It's obviously admissible to Ethan because it's a statement by a party opponent. It's a statement against interests. So admitting against Ethan is no problem because it reflects his mental state, statements against his interests, statement by a defendant, take your pick of any number of reasons. However, as to the mother, I don't understand why it's admissible because it's not her statement, so it's not a statement against interests. There's no evidence that she coordinated the statement, so they can't get it in that way. And without proof that she read it or was actually aware of it, it can't go to the effect of the mind of the listener. So the only thing left that I can see is the idea that she should have read it, and somehow that failure to read it because she's a parent, she has some sort of affirmative duty to read it, and so therefore the failure to read it is somehow a problem. But I don't really understand the legal reasoning off the top of my head about this for admissibility against the mother. Unless, of course, the mother said that she had read it, right, during an interview or something, that would do it. So if the mother said, "Yeah, I read it," then you're golden. So unless they have something like that, I'm a little confused. Yeah, I mean, the journal says EC talked to them, but that's hearsay. That's hearsay because it's a statement from Ethan, right? And you're offering it presumably for the truth of the matter asserted that it in fact happened. So it's hearsay. You can't do that. I assume there was a motion in limine on this issue pre-trial, and I assume the judge ruled on this issue pre-trial, and I'd be interested to hear what the legal reasoning is because perhaps I'm just missing something blatantly obvious, which, you know, that's one of the reasons you read decisions. It's like, oh yeah, I'm just missing this component. So I assume this issue was resolved long ago, but I'm just kind of confused. They could call Ethan as a witness, but Ethan has taken the fifth, so Ethan's unavailable. And you can't get it in through a witness unavailable exception. So, yeah. Yeah, so if anyone out there understands how we're getting this in, I'm happy to understand this because I'm confused. We're not doing the chat crawl today because we're doing it in Stream Elements and or Stream Labs rather, apologize. And they don't have a chat crawl option, so we're trying something else. We're just trying something different. If Ethan pled guilty, why would he take the fifth? He's appealing his sentence. So his statements could be used against him related to his sentence. He pled guilty. He agreed not to appeal the conviction, but he didn't agree not to appeal the sentence. And so he is invoking his fifth because his statements could be used against him with respect to his appeal.
Run past Madison, Anna, and Kylie.
And apparently the decision to invoke fifth was relatively new too, which is also interesting, just sort of thing. Apparently Ethan only made the decision to invoke the fifth like a week before trial.
Respond.
So that wasn't the expectation.
Drive up right to the door if you have to. And go in. search.
Yeah, I know the judge allowed it in. Obviously, the judge allowed it in. I just don't know why the judge let it in.
And eliminate the shooting.
So that's my whole point. Why did the judge let it in? What am I missing? What is the legal reasoning? That's what I want to know.
Because the situation was active and the killing hadn't stopped. You can't stop and render aid. I know.
Your Honor, can we take a break, please?
If I could just finish this part, I'd appreciate it.
I'm sorry.
No problem.
We're having a hard time. He's having a hard time.
I know those officers. And that is the hardest thing.
Ethan was going to be a witness for the defense. Ethan was going to be a witness for the defense.
We take a break, Jeff.
Yeah, we'll take a 10-minute break.
All rise for the jury.
Is there a reason for appeal since defense objected? I don't think the defense did object. That's why I'm saying. The defense didn't object. I would have been objecting hearsay. So I'm confused. When you say a lot louder or a little louder, you're going to have to be clear what you want louder or a little louder. A lot louder doesn't tell me what you want louder. You have to be clear when you say things like that. Yeah. Yeah, so I'm just slightly confused on, I mean, obviously the judge allowed it. I mean, that much is clear. The defense didn't object, which seems odd. I assume this whole thing was covered pre-trial, but even if it was, the defense would still have to object, presumably to preserve the objection. But they didn't make the objection. So I'm very confused about what's going on here. Okay, all right. So the defense attorney asked the judge before court not to object in front of the jury since she's already ruled. Okay, so she did preserve the objection. She didn't want to make the objection in front of the jury. Cool. All right, so she preserved the objection. Fine, great. All right, but I'm still curious as to why the objection was overruled. So the defense preserved the objection, but I want to know what the judge's reasoning is. Because, you know, I could be wrong or I could be missing something obvious. That's one of the reasons. That's one of the reasons I like to read court decisions, because I want to read the decisions and follow their reasoning. And more, you know, relatively frequently, I read a decision and I'm like, oh, okay. Right? They explain their reasoning. I'm like, oh, okay, that makes sense. You know, I couldn't necessarily see it right away, and the court explained something. I'm like, yeah, all right, that's where it makes sense. You know, which isn't incidentally to say, by the way, necessarily in those situations that if I were the judge, in fact, that I wouldn't have made the same decision, because if I were the judge, in fact, I would obviously know everything. And therefore, I would be making my decision in a more informed way. So as I'm reading court decisions, obviously, I don't know everything. I'm only knowing limited pieces of the puzzle. And so I'm like, yeah, that doesn't make sense. And then the court explains the whole puzzle. And I'm like, oh, okay, now it makes sense again. So a lot of the time, it's just like, okay, yeah, I would have made the same decision now that you've explained it to me, because I didn't get it at first, because I can't know everything, because there's too much law and too much stuff is happening, and it confuses me. Yeah. So, yeah. So I guess we could try to Google in the background. I don't know if we can find a reason on this on the fly. This is, yeah, trying to find a decision on this on the fly, or reasoning on this on the fly. I mean, it's definitely in the record somewhere, but trying to find somewhere in the record on the fly is, you know, not easy. Would I make a motion for mistrial? Well, at the end of the state's case, of course I would. Well, I'd make a motion. No, I don't know about mistrial, but I'd make a motion for, you know, I make any motions I need to make. Ethan, journal, suppress. Motion. Ugh. I wonder if MLS has it. Or knows what's going on. No, for the journal. The video is understandable because the video is depicting the crime. So that's easy, right? Because we have to prove the murder. So showing the video that shows the crime, that makes sense. The journal's the thing I don't understand. Yeah. So if you happen to find a copy of the decision relating to the motion in limine, if you happen to find a decision relating to the motion in limine as it relates to the journal in her trial, I would like to know what that is because I'd like to know if I'm missing something because I want to be a good legal educator and I don't understand what's going on. If I don't understand, then I can't teach. And that's not great. Do I have Westlaw? No, not really. Do you have Westlaw? Yeah, no, I don't have Westlaw anymore. Westlaw's way too expensive. I have Fastcase, which sucks. Yeah, which I got for free by being a member of the Virginia Bar. I just as soon use Google Scholar over Fastcase for my legal research, to be quite honest. Google Scholar isn't actually too bad. I mean, it's not great. It's not Westlaw or Lexis, but, you know, it's better than Fastcase, so, eh. So, yeah. Thank you for the 583 of you who are currently here, by the way. We always aim to give good quality legal education whenever we can. We like to explain things to you, and if I'm confused, I don't mind telling you I'm confused because, you know, a wise man knows what he doesn't know, and a wise man will say when he doesn't know. It's like, I don't know. Rather than BS and bullshit, it's like, yeah, I don't know. So I appreciate that you're here. Yeah, some public libraries still have access to Westlaw. Sure. Yeah, I mean, I could go down to the Supreme Court. I mean, yes, there's any number of ways for me to get access to Westlaw. I just don't have it accessible at my home. So sure, if I went down to the state Supreme Court building, which actually isn't that far from my house, yes, I could go to the state Supreme Court building and go to the law library, and yes, I would have access to Westlaw. But I can't do that right now because I'm streaming with you, and it's a little inconvenient in between breaks. We read the interlocutory appeal on the Crumbleys on the issue of can they be charged. We've discussed the interlocutory issue on can they be charged. We've discussed the Court of Appeals reasoning. And then when they explained it to me, I was still like, yeah, I'm not sure about that. So once they informed me, I was still like, yeah, I'm not sure about that. I don't know about that one. So I don't mind. I'm not sure why I say we sometimes. Maybe because I'm thinking about you, the chat, when I say we. That's the only thing that makes sense because I feel like you're part of me somehow. So when I say we, it's like we do this. Maybe I'm thinking of you. I don't know. But I have no problem disagreeing with a judge. I disagree with judges all the time. I disagree with the U.S. Supreme Court. I disagree with them when they're 9-0. But of course, when I disagree with them 9-0, it's because I know what I'm talking about. At that point, I've, done my due diligence. I've read the decision. I've read the reasoning. I've done my due diligence, and I'm like, yeah, no, I disagree. So, for example, when it came to the issue with Chief Justice Toll in the Murdaugh trial, and she's like, the right standard is State v. Green. And people ask me, is that the right standard? I'm like, I don't know. I haven't looked into it enough to know. So I'm not prepared to disagree with the Chief Justice Toll about her understanding of the law until I actually do enough due diligence for myself to be like, yes, she's right, or no, she's wrong. So I've often said when discussing that, it's like, well, if she's right on the law, then she's right on the conclusions. So assuming she's applying the right law, her decisions in court are correct. Is she applying the right law? Don't know. Not sure. Haven't done enough due diligence on that one. They could call Ethan as a witness, but unfortunately, Ethan has taken the fifth because his appeal is still ongoing, and you can't call someone to the stand just to have them take the fifth. And he's made very clear in his filings through his lawyers that he has no intention of taking the stand. So Ethan is not available as a witness. So, yeah. I haven't really been practicing for the last year and a half. No. I've done a little tiny bit of side work, but mostly no. I've been on sabbatical because I got a little burnt out and I quit my job and I need a different job. So no, I'm not. I suppose hyper technically I'm practicing law, but let's just say no because it's way more accurate. And yeah, I'm kind of burned out. So I took a break. I am an expert. I am an expert. Yeah, I am an expert. I'm a 15-year attorney. I'm licensed in Texas, Virginia, and before the U.S. Supreme Court. I have at least 2,500 videos on my channel discussing the law from all kinds of perspectives and all kinds of cases. I'm particularly well informed when it comes to constitutional law. My brethren in the LawTube community have consistently recognized me as basically having the best legal knowledge when it comes to constitutional law. I appreciate their collective validation on that score, that I'm the best when it comes to constitutional law. So yeah. But one of the ways you know how you know I'm an expert? You know how you know I'm an expert? Because I'm willing to say I don't know. That's a pretty good sign I'm an expert. Or at least an honest expert. Because I'm an expert and I was like, I don't know. That's a pretty good sign I'm an expert. I know what I'm talking about and I know what I don't know. I'm pretty good as an expert, yeah.
We were just notified by a victim advocate that there were victims and family of victims using the restroom in the hallway, and apparently a juror was in the same restroom as the juror walked out. There was no communication, no words spoken. I just wanted to place it on the record.
Okay, no, I appreciate that. At one time, I mean, I don't want to tell you the inner workings.
I've never had the pleasure of presenting in front of the Supreme Court. That's a tough gig to get.
Personality issues, we have privacy issues. There are 4 bathrooms there, so, okay.
Thank you. I just wanted to make.
No, I appreciate that. It's, that's why I don't want them going to the cafeteria. Okay. Ready for the jury?
Yes, sir.
Why juror bathrooms in a public area? They would be, except for the deliberation room. There would be bathroom there, but
All right,
yeah.
for the jury?
I don't know how this courthouse is constructed, guys. I'm also not an expert on the finer points of this court's architecture. So, yeah, I don't know that one either.
All right, you may be seated. Lieutenant Willis, you are still on your oath, all right?
Yes, Your Honor.
Go ahead, prosecutor.
Thank you. Sir, you mentioned earlier that you directed officers to the Crumbley family home at 112 East in Oxford?
Correct.
Okay. And approximately how far in distance is that home to the school?
A mile.
Okay.
Yeah.
And as officer in charge and as a sheriff's office employee, you're aware that vehicles have in-car recording capability?
Yes.
Okay. So I'm going to show you what's been, I believe, stipulated to is Exhibit 341. This is an in-car video of Deputy Zajak's marked patrol car. That's 341.
I'm sorry, I'm just.
Was that admitted through Joe Bryan or not?
No, just 342 was.
And
342.
I'm sorry, we have no objection to 341.
Right, 341 is admitted.
And, sir, so we're clear, the deputies arrived at 112 East at 2:48 p.m., 2:49 p.m.,
Yes.
and that's November the 30th, 2021?
Yes.
Okay. And as we saw in the video, the shooter was taken into custody at 1 p.m.
Yes.
Okay.
The courthouse
Correct.
feed is about as high as it gets. Is it really that much of a problem? I could boost it, but it sounds good to my ear. Is it really low? It sounds pretty good to my ear. Do you really guys need more volume on the trial feed? Because I could install an extension to boost it, but it sounds pretty good to me. But then again, I don't know how it sounds to you. So what's the consensus? Do you guys need more feed?
Can you take the handcuffs off of her, please? Okay, plug in first.
Well, I should be louder than the court feed. That should be true. Court audio is low. You're much louder. Turn your mic down 25%. Okay.
No, I asked them the same fucking thing.
They didn't do anything.
Who knew Earth, Wind, and Fire was going to make an appearance? Do you remember 21st night of September? Okay. All right.
I'm getting claustrophobic. I'm getting claustrophobic.
I mean, don't freak out in front of the house. This is going to be a lot better if you don't make the situation.
Why are they here? Why are they here? Okay, can you push my glass in my nose, please? Put chapstick on my lips, please. And hit my fucking phone. I'm so confused.
Why are you in fucking handcuffs?
Put your phone again.
I set it down and then I have a cop pointing a gun at me.
Why are they in our house? I'm so confused.
We're dealing with this shit. Already dealing with shit. Why have we got to deal with this?
Thank you, Pablo, for the becoming a member. We do appreciate it. Thank you. You know what would be really hilarious? I just had a fun idea. If police started putting together a Spotify playlist of songs to confess to, that'd be hilarious. Because people put together like playlists for, romantic encounters and stuff like that, dating or, mood setting or all kinds of lists. So is there a Spotify playlist somewhere where the cops have found all the songs they need that will help encourage people to confess? That's what I want to know in my life right now. And if not, there really should be. Pressing on. Yeah, exactly. Is there an arrest/confession mixtape out there? What song? Here's a good one for the chat so you can participate. What songs do you think should be on the arrest confession mixtape? Please provide your suggestions in chat.
Jen, he can't hear you. I love you in case something happens.
I don't think "Wasn't Me" is really a good one for the cops. Yeah. I don't think "I Fought the Law" and the Law one is also a good one for the cops. I'm not sure you guys understand the assignment over here in chat.
So, sir, that video started at 2:49 p.m. November the 30th. This was after they had spoke with Sergeant Joe Bryan at the Oxford substation, correct?
Yes.
Okay. And the video that we saw with Sergeant Pesky, that occurred directly after this.
That's correct.
Okay. So when she was taken out of the vehicle, she was placed in a different vehicle, and that's where Sergeant Pesky spoke with her.
Correct.
Okay. And then as Edward Wogrowski testified, they arrived home from the location data at 2:30 p.m. after the substation.
Yes.
Okay. Sir, do you know the date in which Jennifer Crumbley was charged?
December 3rd.
Okay, so the
I'm
shooting happened on Tuesday.
I'm starting a YouTube community post on this issue.
That's correct.
Okay. And
I believe it was noon.
So we're going to have that so you guys can comment there some more because this is just way too good.
the process to actually have the charging document.
So the prosecutors give me a warrant. I go in front of a judge and I swear to the facts of the case. The judge authorizes the warrant.
Okay. And that's what we commonly refer to as a swear to?
Swear to, correct.
All right. And did that happen in this case?
It did.
Is that a closed proceeding or is that open to the public?
It was open.
Okay. In fact, it was broadcast at that point.
There was media present for that, yes.
Okay. And they were, Jennifer and James Crumbley were not in custody at the time of the swear to, is that right?
That's correct, they were not.
We've already heard from Dave Hendrick about the fugitive apprehension team in that part of the investigation. Tell us, please, how retired Sergeant Hendrick's team got involved.
So, upon being made aware that charges were coming, we knew that they weren't at the residence. So I had Sergeant Hendrick, who worked for me, deploy the fugitive apprehension team to locate the suspects.
Okay, and that's purely a law enforcement function. Would that be correct?
100%, yes.
Okay, so as the detective lieutenant in charge of all of these different divisions, that includes the fugitive apprehension team?
Yes, sir.
Okay. So the decision then would have ultimately been yours.
Yes, I told him to go attempt to look.
All right, we now have a community post on my community tab. Further comments
that
can be
was-
directed there.
Was that on Friday the 3rd, or was that prior to Friday the 3rd?
I don't recall.
Okay. He testified yesterday that he recalled it being Thursday the 2nd. Is that accurate, or you just don't remember?
Yeah, I don't. I think it's accurate, but I don't remember it specifically.
Okay, that's fair. Now, during the course of your investigation as the officer in charge, did you learn where the defendant went after her phone was seized in the evening of November 30th, 2020?
Thank you, Robin McCain, for
Yes.
becoming a member. We do appreciate everyone who hits that beautiful,
As a
beautiful join
reference
button.
point,
Thank you so very, very
Lieutenant
much.
Sam Marsden testified yesterday as to the date and time when her phone was seized. You were here for that testimony?
I was.
Okay.
Further comments
So
about
I'm
what
gonna
song
have
should be on the
you walk us through
playlist?
that timeline.
Come on, what were we talking about?
Now, we've
Do I
heard
have to
about
spell
your
everything out?
phone purchases.
Yes.
Did you discover where those purchases were, where those purchases occurred?
Yes, at a Walmart in Lapeer.
Okay. This would be exhibits. This is exhibit 404. I don't believe we have an objection.
Any objection?
Thank you very much, next to Kim, for becoming a member. We really appreciate everyone who, for only 99 cents a month, hits that beautiful, beautiful join button. Thank you so very, very
Okay, so,
much.
this is a photograph of the exhibit. What are we looking at here?
This is the purchase receipt for the track phones from the Walmart in Lapeer.
Okay. And did you learn where they stayed that night?
They stayed at a hotel in Lapeer.
Okay. I'm going to show you exhibit 405. I don't believe there's an objection to 405 either.
No.
405 is admitted.
Thank you, Judge. This is 405. What are we looking at here?
This is a receipt for the overnight stay at the Holiday Inn Express in Lapeer.
Now, did you do the swear to for the shooter as well?
Do you really want to
when
hurt
did that
me?
occur?
Murder was the
That
case
was,
that they gave me. That's not bad. I like that suggestion.
It was on the December 1st. I want it. Time was sometime in the early afternoon.
Okay. If I said 3:51 p.m., would that sound right?
Thank
that
you,
sounds
Ren Ogden, for becoming a member. We do appreciate. Thank you so very, very much. You're awesome.
Yes.
And
it was,
thank you, Jen
swear
Pearson,
to-
also for becoming a member. We appreciate
typically
all
open to
your
the public.
support.
They
Thank
were
you very,
in-
very much.
I believe they were on Zoom in their vehicles.
Okay. That proceeding's open to the public. Is that right?
Yes, it is.
I'm going to show you. Well, first, let me ask you: did the investigation uncover where they stayed the day after the shooting, December the 1st, 2021?
Yes, it did.
Okay. This is exhibit 408.
No objection.
408 is admitted. 407 is not.
They skipped.
Correct, Judge.
Okay. Thank you.
Instead of renumbering all the exhibits, we thought it.
Oh, no, it's all right. I just want to make
Okay.
sure I was keeping up.
Thank you, Judge. 408. What are we looking at here?
This is an extended stay in Auburn Hills.
Okay. And this is where the defendant and her husband checked in December the 1st, 2021?
That's correct.
Thank you.
Indicated checked out date.
December
Thank you,
3rd,
Jen, for the 10 gift
2020.
memberships. We do appreciate. Thank you so much
Yes.
for helping to support the channel.
Now, we heard from Sergeant Hendrick, retired Sergeant Hendrick, that they recovered a vehicle belonging to the Crumbleys in Auburn Hills.
Thank you, Monica, for hitting that beautiful,
the
beautiful
location
join
where the
button. We do
vehicle was
appreciate.
recovered?
Thank you so
It
much.
Okay. This is exhibit 409. Photograph.
No objection.
409 is admitted.
Okay. What are we looking at here?
This is one of the two vehicles owned by the Crumbleys backed in a parking spot at the extended stay in Auburn Hills.
Now, during the course of this investigation, we're banking records.
Tony
of the
P,
Crumbleys.
our ever reliable
Yes.
mod, gifts 10 gift memberships to the channel.
Specifically
Thank you,
on
Tony,
December the
for your
2nd,
continuing support.
Thursday, did you find that they had withdrawn cash on multiple occasions?
Yes, they did.
This is exhibit 411. I believe this is covered under stipulations as well.
That's, I'm sorry, did you say 411?
411, yeah.
That's not 411.
No, the next slide. I don't want to publish it until you confirm that it was stipulated to.
Yes, it is.
Any objection to 411?
No objection, sorry.
411 is admitted. And again, 410 was not
Correct, Judge.
previously.
Yes, thank you, Judge. Okay, what are we looking at here in exhibit 411?
This is a withdrawal of $2,000 withdrawal transfer, $2,000 from Flagstar by Jennifer Crumbley.
Now, Edward Rogowski told us about replacement phones. Did you uncover that James and Jennifer Crumbley, after buying their track phones, bought another set of phones?
Yes,
Okay. And do you know the date and location where that happened?
that was in Owasso.
Owasso, Michigan?
Yep,
Okay. And that's on December the 2nd, 2021?
I'm sorry. Yes, it was on December 2nd.
Okay. This is going to be 413, the T-Mobile receipt.
No objection.
413 is admitted.
Yes, just 413, correct. All right. And so what are we looking at here?
This is the purchase of the 2 replacement phones.
Okay. And that was Owasso, Michigan, on December the 2nd, 2021?
Yes,
Okay. What's the relative distance from Owasso to Auburn Hills?
it's about an hour.
Now, did they obtain more cash in this time frame?
Yes, they did.
Back to the banking records. This is 411. No objection to this. I believe we've stipulated to this. Is that correct, Counsel?
Yes.
Yeah.
411, okay. This is Friday, December the 3rd, 2021. And what is the withdrawal amount of cash in this exhibit?
$4,000.
Now, was evidence uncovered in the investigation that showed you a transfer or withdrawal was made from the defendant's son as well?
Yes,
This is exhibit 414. Again, it's covered under stipulation. Move to admit.
You have any objection to 414?
No objection.
414 is admitted.
Thank you. So what are we looking at here in exhibit 414?
so this is the Simply Kids savings account, Ethan Crumbley's account.
Okay. And specifically on November the 30th, 2021, do you see a withdrawal from that account?
Yes, there was a $3,000 withdrawal that day.
And November 30th, is that significant to you?
That's the day of the shooting.
Okay. And how much was left in her son's account?
99 cents.
So what we can tell from the banking records and messages, at this date and time, the defendants obtained $6,000 in cash, $3,000 transferred from their son's account, and they were attempting another $5,000 from horse sales.
That is right. Yes, sir.
Now, do you know where the defendant went after she checked out of the Auburn Hills motel?
They traveled to the address in Detroit, the warehouse.
Okay, and that's the address that William Creer testified to yesterday, 1111 Belleville?
Bell, yes, correct.
So I'm going to show you portions of that exterior surveillance footage that was obtained. Before we do, we've already talked about the timestamp difference. The timestamp on the video is about 22 or 23 minutes fast. Is that correct?
Yes.
So these will be, we marked them separately for convenience as 415 and 416.
Okay.
And the people will move to admit and publish now. We'll start with 415.
Any objection to 415 or 416?
No objection to 415. There is an objection to 416 because Mrs. Crumbley's not a part of it.
Judge, I think it is relevant to show what happened with the vehicle and why, especially in light of Mr. Kirkley's testimony yesterday and Mr. Creer's testimony yesterday.
Your Honor, it doesn't involve Mrs. Crumbley, so I would object.
I think it's relevant to their activities, and it's non-testimonial. I'm going to admit it for
Thank you,
16.
Thank you. Again, I'll start with 415. Before we hit play. Again, the timestamp is 11:20 and 35 seconds on November the 3rd. I'm sorry, December the 3rd, 2021.
That's right.
Okay, so actual time would be approximately 10:58 a.m.
Correct, sir.
Okay.
I hear those sleigh bells jingling, jing, jing, jingling too. It's lovely, rather for a sleigh ride together
What do
with
see in the video
you.
is the 11:21 timestamp?
Yeah, so that's a friend of the defendant who activated the security gate to open it, and the defendant pulled in and parked.
Okay, and again, this is the parking lot at 1111 Belleville in the city of Detroit.
Yes.
Tell me if you see anybody you recognize.
I recognize the defendant.
Maybe this person right here.
Yep. Yes.
And your friend you identified as this individual.
That's correct.
Is James Crumbley depicted in this video as well?
Yes, that's James there.
Right here in the magnified portion?
Yes.
Okay. Okay, now I'm going to play you 4:16. Before we start again, the timestamp is 16:10. What is, first of all, what is 1600 hours?
That's 4 o'clock in military time.
Okay.
4
And,
4 p.m.
and this would be, so shortly before 4 o'clock actual time on Friday the 3rd.
Yeah, 3:48, I think, or something like that.
Giddy up, giddy up, giddy up, let's go. Let's go to the art studio. We can hide out together there while it snows. Giddy up, giddy up, giddy up, it's grand. Fleeing the man. Is my mic super loud? Is it distorted? Again, we have to play with the volume levels, but you guys have to let me know. Is it distorted? Is it good, bad? I mean, it should be a little louder than court audio, but not like massively louder. And I have turned it down a couple times. We're now at 40%. Do I need to go down more? I mean, obviously I want my audio to pick up over court audio. So all right, cool. Thanks. My mic is extra bassy. Yeah, I did put on a setting for that. I could change that out, but let's change it. Let's change the mic setting and see what this does, and see if this is better. Okay, so we can try this setting if we like this better. If this should be more natural from the microphone. If we like this better. A little bit more clean, more natural.
So this is about 4 hours after the charges were officially announced? Is that
That's
right?
correct.
That sounds great.
Okay.
Cool. Okay, we'll stay with that. We'll stay with the natural one.
The fugitive apprehension team began looking for them.
Yes.
Your Honor,
When charges?
Your Honor, I would object because this witness is saying no on the fugitive apprehension team. They came to my office on Friday.
Hold on,
And so
hold on,
he-
hold on.
Wait, okay.
He wouldn't have personal knowledge of the fugitive apprehension team, and he's saying the wrong date.
There's less background noise with this setting? That's surprising, actually, if there's less background noise with this setting.
Testify, but I want to know from his personal knowledge. One thing I think that would be helpful is, I don't think, would anybody refresh your recollection about when the swear to was?
Okay.
The
Yeah,
swear
if there's
to
less
for-
background noise, then we'll stay here. That's
We
great.
mentioned two, Your Honor. So you talking about the swear to for the defendant?
Yes.
The swear to for the defendant was the December 3rd.
December 3rd.
December 3rd.
Okay.
Right.
So when did you contact the fugitive apprehension team?
December 2nd evening or late afternoon, evening time to get an idea where the defendants were, because we believe charges would be forthcoming.
But they said that he said they came on the
You
3rd.
mean Hendricks?
Yeah, and Hendricks came to my office on the 4th.
No.
Okay.
Hendricks, Friday the 3rd is when Hendricks testified that he showed up there, he was conducting surveillance prior to noon.
Oh, he was there without me. Okay,
It's all on the record. I mean.
Okay, yeah, you have to rely on the evidence from the witness stand, okay? And you have to rely on your collective memories and your notes, right? Go ahead.
Thank you. Okay, sir, you testified earlier that the swear to that was broadcast was noon, Friday, December the 3rd.
Yes.
Okay, and this video is around 4 p.m. Friday the 3rd.
Correct.
Okay. Now, Luke Kirkley testified about looking at a poster online, and that's what spurred him to call 911. Do you recall that?
I do.
Okay. And so when a BOL or be on the lookout is announced, is a license plate of a vehicle also given?
Yes.
Okay. Was the license plate on this vehicle in the front of the vehicle or the back of the vehicle?
It was affixed to the back.
Got it. Now, sir, Mr. Bobrowski already testified about the location data for Jennifer Crumbley on the day of the shooting, November the 30th, 2021. Do you recall that?
I do.
Okay, and as officer in charge, you're aware of that information that he uncovered?
Yes.
Okay. Just want to confirm that Jennifer Crumbley never stopped by her home at 112 East after meeting Mr. Hopkins at the Oxford High School?
No, she went directly back to work.
Okay. Now, you've had the chance to review phone logs as well as other information from social media and information obtained from Jennifer Crumbley's phone?
Yes.
Okay. And sir, do you have any experience getting someone same-day mental health help?
Yes, I do.
Are there facilities available for that?
Yes, there's a facility on this complex called Common Ground that's available for that.
In reviewing the phone logs of Jennifer Crumbley, is there any indication of any phone calls to a facility of that sort?
No.
In fact, any phone calls to any doctor's offices,
No.
counselor offices,
No.
any hospitals,
No.
any mental health professionals at all?
No.
Thank you. I have nothing further.
Cross.
okay, thank you. Sergeant Willis, I want to go back to the pages from the shooter's journal that were admitted. You don't have any evidence to suggest that Mr. or Mrs. Crumbley ever saw the journal, correct?
I'm sorry, miss.
You do not have any evidence to show that Mr. or Mrs. Crumbley ever saw the journal.
I'm sorry. It's been a tough day. So you're asking me do I believe Mr.
No.
or Mrs. Crumbley?
I'm asking you.
Oh,
you
do I have
any-
evidence?
Do you have any evidence to believe that Mr. Crumbley or Mrs. Crumbley saw the journal?
No, if I had evidence of that, I imagine the charges would be different.
If you had evidence they saw the journal, the charges would be different?
Yeah, murder, I
Okay.
would imagine.
Okay, so the journal was located in the backpack that belonged to the shooter,
Yes,
correct?
correct.
There were also a number of other papers in that backpack that you described.
Yes,
You don't have any evidence that Mrs. Crumbley ever saw any of those papers, correct?
correct.
Now, in the journal, you've testified about certain statements the shooter wrote in the journal, correct?
Yes,
And specifically, one of the statements that you testified about was where the shooter wrote, "I have access to the gun." Is that correct?
yes,
In the journal, there are other statements where he indicates he is looking for the gun, correct?
Can you tell me which ones you're referencing?
Sure. So I'm gonna hand you, Your Honor, may I please approach?
Sure, just show Mr. Keystridge.
Sure.
I have a copy of it too, if that helps.
Judge, just briefly, this was subject of a prior court ruling.
Yes, so
And-
I ask everybody to be really careful. All right?
Okay, so I was gonna show 788, just this one line.
Okay, again, Judge, maybe we should have a minute outside the presence of the jury.
Are we doing this again?
Your Honor, can we just approach and I can show you?
I have it, and I know
Do you
exactly
want
what it
to,
is.
do you want me
No,
to-
it's not that. We have to discuss the court's prior ruling.
Your Honor, I think, okay.
All right, I'm going to excuse you for 10 minutes, all right?
All right, we're doing this
All eyes
again
for the jury.
on doors and opening doors or whatever else we're doing. Oh, man.
Fine, you can read people's minds. Is that what she's seeking to do? Are you
Yes.
seeking
That's
to
what it
do?
looks like.
That's correct.
Are you seeking to do anything beyond that? Be specific, because I
There's,
can't unring the bell, right?
that's correct. I'm seeking to do those two with the claim about access to the gun. And the detective also testified to a statement about, I'm going to get the gun. So I wanted to impeach him with, on 789, there is a statement that says, it's one line, however, I don't want to be caught, as that will make me getting the 9mm impossible.
It's not impeachment because he's not the declarant.
Well, I'm hamstrung because these statements are coming in by a declarant that I'm not allowed to call as a witness. And under the
Okay,
same,
look, I want to back up a second. I never said that you could not call the shooter as a witness.
I was getting the vibe that would be the ruling of the court.
No, that'll never be the ruling of the court. I'm not telling you that you can't. I am not, as a judge in this court, telling you you cannot call the shooter as a witness. However, we've been over this before. We're going to go over it again this afternoon. Pursuant to case law that everybody's aware of, including
I already know what the judge is going to say, and I don't know how that's the same thing as saying you can't call the witness. She's about to say the witness can't be called because he's invoking his fifth, and you can't call him merely to invoke his fifth. But how that's not the same thing as saying I'm not saying you can't call the witness. Eyes beyond me. Okay, I don't get it. All right, let's see what she says.
a case called Jackaloni. It's 399 Mich 642, a 1977 case. No one is allowed to put a witness in front of this jury who was going to take the fifth. No one. It's not me.
Well,
I'm not keeping you from calling someone as a witness, but his Fifth Amendment rights have been asserted repeatedly. And I can't let you put a witness on the stand. Anyone, the prosecution too. I wouldn't let the prosecution put someone on the stand, knowing that that person was going to take the Fifth Amendment, take the fifth. If someone takes the fifth in front of the jury, it's over.
I still don't understand how it's not her doing it. I understand that she's bound by law. I understand it's the correct legal ruling, but she's enforcing the law. So how she's not doing it, because I don't get it. It's a distinction without a difference to me.
It's in this trial. I can't let you do that, right? And I also asked before, aside from what is your favorite color, I can't imagine something you could ask the shooter that would not implicate his Fifth Amendment rights. His current attorneys, the State Defender's Office, have asserted his rights. They have said he will not testify.
I understand that. I have said I would still like him to testify, so I just need a finding by the court that under case law, he's not going to testify.
I'm not making a finding that he's not going to testify. His lawyers have asserted the fifth. You're not allowed to put someone on the stand that will take the fifth. And in reality, if they say he won't testify, I don't know what am I going to do? I'm going to insist that he testify and then hold him in contempt and put him in jail? Is that?
Well, Your Honor, I understand the court's position, but for the record in this case,
And by the way, I understand your position as well.
I've indicated, As far as our position, I've indicated I don't believe the shooter should be allowed to plead the fifth because he was sentenced. He's made statements about the crimes. He pled guilty to all 24 counts in adult court. And so I don't
So
believe.
you think that's over? Do you think that's over?
Well, I think there is not case law that says he gets to continue his Fifth Amendment rights beyond that plea. I don't disagree with you
His
that
appellate rights?
he's going to pursue an appeal. I don't disagree.
All right, so what would make me think he does not still have Fifth Amendment
Judge,
rights?
there's case law directly on point.
I know, and some of those are indicated in the letter provided by the State Appellate Defender's Office, right?
Yes, sir.
Yeah. I understand your position. I also understand, to a certain extent, I don't, even if he was called as a witness, you understand that then the prosecution would have a right to cross-examine him, right? So, I'm not keeping you from calling him. The law is keeping you from calling him. You are not.
I don't understand the distinction. I really am I'm really struggling to understand the distinction. I'm not keeping you from calling him. The law's keeping you from calling him. I don't really understand the distinction because one of the reasons that judges wear black robes is because, as Sandra Day O'Connor put it so well, by putting on the black robe, they are embodying or imbuing themselves or taking on the persona of law persona. They dismiss themselves to become, in some sense, the avatar of the law as a person. And so for her to say it's not me, it's the law, I don't get it, because to some degree, she doesn't exist. So I'm confused by the distinction.
Permitted to put someone in front of this jury who is going to take the fifth.
I understand.
Yes.
That's the ruling then, that the law doesn't allow me to. Is that correct? Okay.
By smarter, higher courts than this one.
If that's the ruling, is that the court is going to follow the law the court said.
I'm going to follow the law.
Then
Of course you're going to follow the law.
I've preserved the record and I'm moving on.
Okay.
So then these statements are coming in. They've come in as present sense impressions.
Okay.
And
Present sense impression. No. I don't. No. No.
and I'm not using them at all for the truth of the matter asserted because I don't know whether he found the gun or didn't find the gun or was looking for the gun. But this statement shows his state of mind, so I believe it falls under the exception, saying he doesn't want to be caught because it will make him getting the gun impossible. So his state of mind is not wanting to get caught. And that's...
Hearsay is any out-of-court statement offered for the truth of the matter asserted. The journal is hearsay because it isn't by... The journal is a statement. It's an out-of-court statement, and it's being offered for its truth. And she's like, oh, I'm not offering it for its truth. I'm like, yeah, sure you're not. Uh-huh, okay.
That's important impeachment to the testimony from the detective that he said he was going to get the gun.
Okay, so are you addressing that statement, or also there's the, I don't know where my dad hid it, and there's a statement, I have to find where my dad hid the 9mm.
The two hiding ones are one issue, and then the second issue is I don't want to be caught.
All right, and
And that's it.
okay, do you have any legal support for that? Just present sense impression.
And just straight impeachment rules.
Again, impeachment doesn't apply here. Impeachment is if a witness makes, he didn't make the statement. I mean, that's
Well,
not in dispute. It's not impeachment.
I can impeach through other witnesses. I can impeach by omission. I believe under straight impeachment rules, I can use this. This is being admitted as substantive evidence. So I can impeach with something written on a napkin.
Okay, but I guess what he's saying, and this came up too, with regard to the privilege records.
Correct.
Which we'll talk about again. Who are you impeaching though?
I'm impeaching the shooter's statements that have been deemed substantive evidence. And I'm not given the option to impeach through the shooter, so I'm seeking to impeach through the officer in charge.
Okay, so why wouldn't I allow those statements, Mr. Keith?
It's not permissible. It's not under, and council has not cited the rule for that. It's not permissible. And I just want to inquire of the court if council is permitted to do that. Am I allowed then to ask about other passages?
Well, that's what I'm concerned about.
I mean, there are
How
a
do
number
they
of,
relate to this?
I mean, just in the first 2 pages alone, Judge, we have
Impeachment just means to discredit. It just means to contradict. Someone said something on the stand. Here's something that says something different than that. It's just essentially an inconsistent statement. That's all it is. You know? And so please explain the inconsistency. That's impeachment.
you see the picture of the gun on Instagram, we'll know what's up. We have,
Yeah, all of these things, all these things, with exception of the period of time that I was stayed by the Supreme Court, to me could have been addressed, so this sort of doesn't feel like the time to be doing this. But.
Earlier in the trial, when I found that the court wanted to know what objections were going to be made, I stood up and said, I know this is going to be an issue, and the court said, we'll handle it down the road in trial. I made the court aware of that. That was on Monday or Tuesday, when there was some friction about another objection. I said, this is going to be coming, and the court said, we'll cross that bridge when we come to it.
Okay, because I guess my position is that we should have crossed that bridge before we impaneled a jury. That's just,
Judge, we put the passages the court specifically ruled as admissible, nothing more.
Okay, but why would her request to allow those three passages because they're present sense impression?
Well, I don't necessarily agree there's present sense impression, because there's certain requirements for present sense impression as well as state of mind. We can't be talking about a future plan. And there's Brady, his friend is gone, he has no friends. My wrist hurts from writing in this, fucking book so much. I haven't felt generally happy in years. I can feel the evil around me, even dogs sense it. I mean, that's just on page 5.
That doesn't impeach, though, anything that I'm using, and the prosecution didn't seek to admit those things. I also didn't...
We've only admitted what specifically would be covered under the rules that the court permitted us to over a year ago.
Yeah.
We're not trying to push the envelope here, because as the court is, we don't want to inject any kind of error, Judge. So we kept this extremely close to what the court has specifically authorized.
Well, which provisions specifically do you say are present sense impression? Because I don't know that they are. I don't know that they are.
I still don't know on what basis we're allowing the journal at all. That's the thing. That's the confusion to me. So I'm still back with, why can the prosecutor offer the journal at all? And why does that reasoning not apply to the defense as well? So I'm still confused back where I am, because I don't know what's going on. I mean, I understand the idea in principle that portions of it could be admissible without other portions of it being admissible. I get that, but I don't know why any of the journal's admissible, so I'm really confused. Because I don't know what basis the state is getting in with. Present sense impression? That doesn't make sense. If it's present sense impression for the state, how can it not be present sense impression for the defense? That doesn't make sense. I don't get that. Because the prosecutor says, well, we don't think it's present sense impression. But how can that be true with respect to statements in the journal, but not respect other statements in the journal? I'm so confused. Present sense impression is literally I'm observing it as it's happening. A classic example would be look out, that guy is speeding. Right. And so I'm offering it because it's essentially excited utterance, if you like. It's a comment made while the thing is happening. That's present sense impression.
On page 788, I don't know where my dad hit it.
I'm finding the provision right now.
It's just, my concern is more along opening the door.
Yeah, that seems to be the theme.
We're going to break out the rules of evidence now.
Opening the door to all the texts coming in. I believe impeachment is.
Present sense impression for the text makes more sense. Although a lot of those texts were to the mother, so you don't need it. The text to the friend is more questionable for the same reasons. So text between the mother and Ethan are fine because that's party opponent. Mother's comments are party opponent, and Ethan's come in under the idea of the rule of completeness. I'm still confused.
My impeachment is very limited. It's limited to 3 sentences.
I need someone to explain this to me. I don't know if MLS can explain this to me.
Bring under 803.
Under 803.
Maybe I should jump on with MLS and have him explain this to me because I don't understand what the hell's going on.
Emotional, physical condition.
He writes the rules of evidence. Typically, the state Supreme Court does. Although the legislature also sometimes codifies it too, so it gets complicated.
Has to be that existing mental, emotional, or physical condition.
I think that's a existing.
I have a
mental.
headache. I feel sick.
I'm going to hop over to MLS's chat and see if he can explain it to me while you guys are talking, because I don't know what the hell's going on.
And so his plan to give puppy eyes or whatever, his plan to not give puppy eyes, I'm sorry. His plan to act in a way so he's not caught, I think does fit under the rules. Because it talks about intent, plan, motive, design, mental, feeling, pain, or bodily health.
So here's the crux of the issue, is that for 1.5 years, we had just those 5 or 6 portions admissible by the court. This trial was prepared from the prosecution standpoint with just those admissible because the court was very specific in its ruling. And so now defense is using that ruling as a sword and a shield. And so if the court wants to make a substantive ruling mid-trial, I think I'm entitled to at least a minute to.
Your Honor, I'm the one that filed the motion that brought this issue up. I filed an appeal with the Court of Appeals.
I'm aware.
Okay. I got their exhibits after trial started, identifying these portions of the journal.
Okay.
That after trial
You've had
started.
this journal as have I.
As
for
absolutely.
A long time.
I
A
have,
long
and that's
time.
why I filed an extensive motion about it. But now that they're using bits and pieces in trial,
We used only that was identified on June 27, 2022.
it shouldn't preclude me from impeaching.
Okay, but that's what I'm going back to. Who are you impeaching? What rule allows you to impeach someone who's not testifying?
It's complicated because I can't impeach the person that I want to impeach through testimony. So you're right. I'm hamstrung. My client has a constitutional right to present a defense, though,
I'm aware of that.
and I'm getting hamstrung and stuck because of other extraneous legal issues. This is straight impeachment. So what I'm providing is not going to be admitted as substantive evidence. It's impeachment.
So she's being hamstrung by her own motions to exclude. Her own motions to exclude. We didn't move to exclude any of this evidence. Counsel did after the preliminary examination, and this court was specific in its ruling.
Well, there should have been a motion to include as well as what they're saying.
There's no rule, there's no requirement for anybody, any party to have a motion.
No, that doesn't make sense.
Especially when counsel specifically identified this piece of evidence as being inadmissible. The court made the rule.
Well, I guess what I'm saying, if you were in fear at all that this court would rule incorrectly, you would still have an opportunity to appeal that ruling.
And we didn't appeal the ruling. We
And
didn't.
No,
Your Honor,
Oh,
I have
yes.
not, I would have filed a motion if there was substantive information additionally that I wanted to admit.
All right, guys.
I've never
All right, guys. I think we're going to go hop over with MLS for a second. So I'll bring him on stream because I need him to explain. And we need to have a discussion with MLS about this because I don't know what the hell's going on. So we'll keep this live. I just want to let you know that we're going to try to hop on with MLS and have it explain this to me because I don't understand what the hell's going on.
filed a motion to have the ability to impeach. I'm asking to impeach. No one files motions to say, may I impeach this?
Because this is the
That's-
third
Yeah.
time during the trial.
There's motion.
All right, no, we're jumping on with MLS for a second because I need a second opinion from another lawyer, so someone can explain this to me. All right, hold on, guys. We're jumping streams. Why do I have two studio links? Yeah, okay. I think this should do the trick. Put this on. Great. All right, let's go.
I believe my impeachment is very limited.
Hey, Kurt. Not a whole lot. Do you know Baker, by the way, below me?
No. Hi, I'm doing fine. How are you?
Yeah. I am extremely confused as well. I was confused when they first said that they were going to allow the journal and the text in under present sense impression. It doesn't make sense to me. Because it's not the witnesses, on the stand that's saying it, or writing it down. But then for the prosecution to say that adding those two additional passages is opening the door to all of it, or that just because or he's only allowed to admit his part. I honestly, I don't know. It doesn't make sense to me either. I'm just as confused as you, and I don't have this motion nor the court's ruling about it.
Yeah, no,
So
I'd
can't
really
dive
like to
in.
see the reasoning on whatever motion to eliminate. I'm sure exists on this issue.
Yeah, there were two motions filed, and actually there was a hearing set for the week prior to this trial starting, which I was going to cover, and then they dispensed with oral arguments, and the judge was going to issue a written opinion. I haven't actually seen that written opinion, so I don't know exactly what the reasoning is. But she made a finding. She said repeatedly under 803.1, which in Michigan is present sense impression. So I don't know. I am absolutely at a loss as to how it's present sense impression and why, like you said, it applies to certain passages but not other passages. I have no idea.
I don't buy present sense impression. Present sense impression is typically I'm observing something as it's happening. I don't really think that applies to your own mental state about what you're feeling.
And it's also used when the witness on the stand is the one that's testifying, right?
Right.
Yeah, you have a cop who didn't know Ethan at the time or was in the room with him when he wrote the journal, but he knows his present state. How? And why can't he then just turn around and say, everything else in the journal, I read that, so I know everything he thought about.
And putting aside that issue, like even if you get to the idea that's a present sense impression, with respect to Ethan, how does that apply with respect to the mother without evidence that the mother knew of it? So, because we're all talking about the mother's mental state, right? So without evidence that the mother was aware of it, then how does it speak to her mental state is beyond me at all.
Did you hear what the officer testified to first few questions on cross?
Yeah. I heard him say exactly, yeah, we have no evidence of this. I heard him say exactly that.
But he said if they had evidence of the knowledge, which is essential to this charge, they would have upped it to murder, which is an intent charge.
Also,
Even though they don't
object
have-
legal conclusion.
I know, right? There was no objection to that, and I thought she should have followed up on that a bit. But
No, I don't buy any of this with respect to the journal. With respect to the text messages with the mom, easy enough. You know, statement of a party opponent. We bring in the whole thing for rule of completeness. The text messages to a friend, I don't know, haven't thought about it hard enough. But with respect to the journal, it's a pretty big thing to bring in. That's a big deal. And I don't buy any of this rationale. Is that you, Nick?
That is me.
You've
Hi,
changed
Judge.
you've changed your look.
It's ponytail, and I trimmed it. Trimmed the beard.
Nick, do you understand any of this bullshit?
This is live. This is live. We are 10
Okay.
minutes behind the court schedule, but yes, we are live. No, Nick doesn't understand anything.
Yeah.
Nobody does.
Yeah,
None
I
of
mean,
us
I'm still trying to get a grasp of why the parents' responsibility is at a criminal level. I can see a civil, but then again, I'm Swedish. We don't have anything close to this here.
Oh, don't worry. I've already raised all those questions before too. Don't worry about that. I'm with you on the law. I read the Court of Appeals decision on the interlocutory. I'm not sure I buy any of this either.
It goes in circles, doesn't it? That Court of Appeals opinion.
Yeah, I don't buy any of this either.
Well, hang on.
I'm hijacking your stream for a while because we can go live. I'm hijacking your stream for a while.
Sure.
It's limited to 3 sentences.
Okay,
In them.
okay, you're offering under 803.
Under 803, let me just find it.
803.3 is then existing mental, emotional, physical condition.
.803.3. Then existing mental, emotional, or physical condition. 2 is excited utterance. 4 is statement made for the purpose of medical treatment.
Someone has to explain this to me like I'm 5. If the statement is, I'm looking for the gun, I can't find the gun, on what possible basis is that not mental impression if any of this other stuff is? How does that work?
Mental, emotional,
I know, right?
Emotional or physical condition.
I don't even agree with the premise, but assuming the premise is true, how's the conclusion not follow?
Right?
It also says such as intent, plan, motive, design, and so his plan.
When 2 lawyers are confused, you know it's all going to hell.
Or whatever,
When the judge breaks out the bench book.
not get puppetized, I'm sorry. His plan.
No, and again, I'm here
act
as
in
the
a way so he's
non-legal
not
fella.
caught, I think does
Like
fit
the 12
under
people who are
rules.
going to convict her. I don't
Because it talks
understand
about
anything
intent,
of what's
plan,
going on
motive,
right now.
design,
And I know
mental
we're
well-being,
watching
or
behind the
bodily
back,
health.
but sitting back there in the jury
Here's
room,
the crux of the issue is that for a year
the
and a
way they
half,
were sent out,
we had just those
and again,
5 or 6
court is not about
portions
law,
in
it's
the
about
Nevada court.
juries.
This trial was prepared from the prosecution standpoint.
And
with
this
just
case-
those dismissal because the court was very specific in this ruling.
It's so confusing
So now-
to everyone.
Defense is using that,
We didn't
that
have the-
ruling as a sword and a shield. And so if the court wants to make a substantive ruling mid-trial,
Wait, who's
I
loud?
think I'm entitled to at least
Court
admit it.
does not.
Your Honor, I'm the one that filed the motion that brought this issue up. I filed an appeal with the Court of Appeals.
I'm aware.
Okay. I got their exhibits after trial started, identifying these
Okay.
portions of the journal.
Okay.
That after trial
You've had
started,
this journal as have I.
as
for
absolutely.
A long time.
I have,
long
and that's why I filed an extensive motion about it. But now that they're using bits and pieces.
She filed an
of
extensive
trial-
motion
Only
to get the whole thing out, and the court allowed 4 or 5 passages in under this 803.1 present sense impression. But now apparently it's not good enough.
I really need the judge to explain this to me in excruciating detail. I need this motion in limine response. I need the judge to explain to me in excruciating detail how some of this is present sense and other of it isn't in a way that makes any sense to me.
Let me see if I can get it while this case.
Please find me the magical order on the motion in
It should
limine.
preclude me from impeaching.
Okay, but that's what I'm going back to. Who
This better be good.
what-
That's all I'm
who
saying.
allows you to impeach someone who's not testifying?
It's complicated because I can't impeach the person that I want to impeach through testimony. So you're right. I'm hamstrung.
I'm allowed.
My client has a constitutional right to present a defense, though.
I'll turn myself down more,
and
I guess.
I'm getting hamstrung and stuck because of
I'll cut myself in
other
half.
extraneous legal issues.
I don't want to blow out your guys' ears. Sorry.
It's not going to be admitted as substantive
If
evidence.
she can't impeach his testimony through the diary and all of that stuff, why was it allowed in?
We didn't move to exclude any of this evidence.
She has the right to confront.
Preliminary examination.
Uh-huh.
And this court was specific in its ruling.
Well, there should have been a motion to include.
That would
And
seem reasonable.
There's
Yeah.
no rule.
And
there's no
if she's not
requirement for
allowed,
anybody,
I
any
would
party
call for a
to have
mistrial.
motion to include, especially when counsel specifically identified this piece of evidence as being inadmissible. The court made the ruling.
Well, I guess if I'm saying if you were, if you fear at all that this court would rule incorrectly, you would still have an opportunity to appeal that ruling.
And we didn't appeal the ruling. We
And
didn't
Your
appeal.
Honor,
Oh,
I have
yes.
not, I would have filed a motion if there was substantive information additionally that I wanted to admit. I've never filed a motion to have the ability to impeach. I'm asking to impeach. No one files motions to say, may I impeach this?
Because this is the third
That's-
time during the trial.
There's motions in limine with regard, this journal is very disturbing and, every time.
Yeah, it is very disturbing, and there's a 403 problem there too, as long as we're
This
discussing
is a
issues.
glaring thing in this trial. This isn't a middle of the trial type of game plan here.
Right, just so the record, just so the record is clear, because I know the court's aware, we went through the Facebook messages detailing alcohol use. We talked yesterday in depth about the extramarital affairs that were previously excluded. And now the journal, this is the third time mid-trial. We just need the ground rules. The court gave us those ground rules a long time ago. We prepared a case in accordance with that. So if the door's open, the door's open.
Okay, well, that concerns me too. I'm going to take a brief recess.
Thank you.
So you can step down.
Thank you, Ron.
yeah, Judge, you might have fucked up in your prior rulings.
All right.
Yeah.
Here we are.
So here we are waiting. Okay. You guys keep talking while I'm looking this up. I'm trying to.
Yep.
I've got it. I just got to find it and order it.
Yeah, I need this. I need someone to explain this to me step by step.
But
how this makes
I don't
sense.
think anyone can explain it to you because again, it's just I'll make a ruling and then someone raised a stink about my ruling. I don't know why I ruled that way. It doesn't make sense. What if this guy can be put in there to talk about Ethan's present sense of mind or whatever it's called? Why can't he do it on the rest of the journal? Well, he can't because I don't know. It's
So the DA speaks from both ends here. Only
Yeah.
what we want in is allowed. What you want in is not allowed.
Yeah, that confuses
yeah, exactly.
me. How's that
That
logic
makes
work?
an inconsistent ruling from the judge, who should have predicted this.
And I don't
Yeah,
even
It
think,
was
that's-
under the rule of completion as well.
yeah, I don't even think it qualifies as present sense because it's not related to the event itself. Like present sense would be someone observing the event. For example, look at that car. Look how fast it's going. That's present sense because you're observing the thing. This is planning, preparation. It's like I'm not even sure you can be criminally tried for what's in the journal before the event occurs because it's planning, preparation, statement of intent. But arguably, there's no act that would allow criminality on its own,
No,
on the own paper.
No, because he can always step back from the crime.
Right. He can always step back and be like, you know what? I changed my mind. I'm not going to do that after all. What a whoopsie thought that was, right? So without some sort of step to effectuate the intent, you can't even get to attempt. So
I have the motion in limiting to strike the evidence. I have the people's response, and
Yep.
I have
do you have the judge's decision?
no.
Okay, that's less helpful.
No. Oh. I mean, I can order those two documents, but there is no opinion or order regarding that.
How's that even?
written.
How's that even possible? How can there not be an opinion or order written about this?
I don't know.
It is.
There's
Additional motions to
Oral
strike.
hearing.
It is a fairly critical piece of evidence.
There's an offer of proof regarding the motion to strike, and then there's a people's response to that.
Someone in my chat is saying the
there's no
judge's.
opinion.
Someone in my opinion, someone in my chat is saying that the judge's opinion is under seal.
There's no.
What?
I mean, that's just what someone in my chat is saying. So I don't know.
There's a protective order that's under seal. Copy of protective order, but I think that has to do with Ethan's. Ethan filed a motion to intervene and notice of Fifth Amendment, and I think that's what's under seal.
Also, by the way, I take exception to the judge saying I'm not the one keeping you off the stand. The law is, as opposed to like, there's a difference somehow.
I know that was so dumb.
Yeah,
I'm just enforcing. I'm just enforcing the law. No, well, no shit. That's your job.
Yeah.
Yeah.
She is
That's
judge.
the
There.
sole
I am
purpose.
the
She's
law.
there. Yeah.
Do you want these? You want these motions, anyways? I don't have an order. Let me see what I can do here. Let me see what these look like. I'll get them shortly. I won't.
I guess we can see what the state wrote in their BS of how this somehow qualifies. I mean, I kind of know what it says without reading it, but
Right.
I already disagree with it.
It's a lawyer speak of we wanna.
Yeah, I mean, I know what it says without reading it. Of course, it's present sense. He's writing this thing as it's happening. It's a real time dictation of the thoughts. Of course, it's present sense. Do.
There's it's like a notebook, and there's 21 pages that were written in, and all 21 pages apparently depict or talk about some sort of school shooting, and his life is horrible, and the gun, and where the gun is, and that he doesn't have access to it, and whatever. There's only one date on it. I don't remember the exact date, but it places it right around between the time the gun was purchased and the shooting. It's like, I want to say it's like November 27th. So it was written very quickly, at least according to the date that was in there.
I am Dave. Trial is on break right now, so that's why we're discussing the trial.
Yeah, you can see it right here. See, we're just waiting.
We are doing just as you want. But again, I just love that all of these state witnesses get the defense dementia. The second he asked, or she asked him a question, it's been such a tough day, I can't remember. You were perfect. You could remember all the kids you saw that day and how bad they were. And the second the defense asked, and I really hate that. I've been doing this for a year now. I hate whenever a state witness who works for the state goes on the stand, they get dementia. They can't remember.
But that is because they've been only prepared for one part of the story. So
That is a fair point. The state has taken time preparing their witnesses. Heaven forbid we use the word coach. And so they know what the state's questions are going to be. So they've had the ability to hone their testimony with respect to the questions.
But Kurt, as a lawyer, wouldn't you also say you might be asked this question, and you might need to prepare an answer, something like this, instead of just sitting there. It's been a horrible day.
I've never been a prosecutor, so I couldn't really say, but I could imagine a prosecutor not prepping you, because then they can honestly say, well, I have no idea. I haven't thought about it.
Yeah, but it just looks, to me, it just looks bad to the jury whenever, because it's always the state's witnesses. Because a regular person, most of the time, will just blurt out stuff, but the people who work for the state, they get the dementia.
Yeah, they're professional witnesses, so they know what to say.
Yeah, and it pissed me off that the prosecution chose to put the most emotional cop they could find on the stand for this part at the end of the state's case.
I've been in doing jury duty for more than 12 years. I have seen one person cry on the stand who wasn't a victim. I have seen two persons who were victims crying on the stands, and they were raped a lot by a guy in a very bad way. The other one was a guy who was the ME, not the ME, but the physician who took in a murder victim, who was, let's just say, the pictures weren't that great to watch. That's in 12 years, I've seen three people cry on the stand. And this guy got so emotional. He's a professional. My dad was an EMT worker for almost 40 years. I never really saw him cry much about his work, because you see bad stuff and you get used to it. To me, it just seemed phony. I'm sorry.
So these are the segments that were admitted. Well, hang on, Kurt. Let me get this banner off your face.
Thank you.
All right. So these are the segments that were admitted. So under present sense impression. So I have zero help for my mental problems, and it's
Causing.
something. Causing me to shoot up the fucking school. That's a present sense impression, apparently.
No.
No, because
I want
he's
help
talking
of my
about
parents.
he's talking about a future event. Then it can't be present. I mean, yeah.
I want help, but my parents don't listen to me, and I can't get any help.
No.
No.
My parents won't listen to me, won't help, or a therapist.
No.
Won't listen to me
No.
about get or a help or a therapist. I want to shoot off
Up the effing school.
Yeah, up the effing
badly.
school. So
I want
badly.
to shoot. Soon I'm going to. That's present sense?
No, and I can see from here that's two different pens.
I'm about to. That's present sense?
I'm about to shoot up the school and spend the rest
How-
of my
how-
life and spend the rest of my life.
How in the world is this accepted by the judge as present sense?
It's not present sense impression. It's just not, because it's talking about his own mental state. That's not present sense impression. Present sense impression is something you observe as a
Yeah,
witness.
And again, the last 2.5 lines.
These are the only parts that were admitted, by the way.
Yeah, I'm fully committed to this. So yeah, I'm going to prison for life, and many people have about 1 day left to live. He can still step back from those thoughts.
Yeah.
He hasn't done it. This is not the minority control
Right.
report. Minority report. We don't do pre-crime.
I mean, it's all the relevant as it relates to Ethan, because it speaks to his intent. Plus, it's a party opponent statement, so it's just non-hearsay in the first place, at least under the federal rules. And so no problem there. But as it relates to the mother, I don't see it.
The other thing is that if this is considered present sense impression, if these things are, then why would it not be present sense impression to admit the parts where he says, I just need to find out where my dad hid the gun, or
That's a really good question. That's the same question I've been asking.
Right? Why, if this is present sense impression, is that not present sense impression? Why do we have to go to these other rules that everyone's looking through?
I know what the problem is, though. I've just figured it out. Just figured it out. If the defense gets this in and the judge is like, well, we're going to admit it all now, and she tells the defense that, it's going to be viewed by the Court of Appeals as waiving the entire objection, because now the Court of Appeals is going to view it as the defense inviting the error. So if she doesn't cross on this because she can't, then she can raise the issue on appeal, like, yo, it came in besides my attempt. But she's like, no, I want to bring this in. And the judge is like, are you sure? Okay. The Court of Appeals is going to view it as waiving the objection. So the judge is basically putting her in a no-win position. Either you do it now and waive the objection of the Court of Appeals, or you don't do it now, the jury convicts, and then you are relying on the Court of Appeals to say, you know, this was legal error to the point that it requires reversal, which they're not going to do that either, because the Court of Appeals is going to say harmless error. Well, yeah, it was a mistake to let it in, but so much other evidence, so who cares, right? So she's being put in a no-win position.
Yeah, and this goes back to the judge to protect the process, she should go back on a ruling. The problem is you can't shove the toothpaste back into the tube.
There's no way she can go back without declaring a mistrial.
Yeah.
Yeah, because the
but
jury is
she should.
now.
She should, but she won't.
I mean, if you realize as a judge you effed it up that hard, then that should be what you do. You know, it's like, well, that was a mistake. Let's try
This has been
again.
extremely stressful on her and the whole court administration, because they made a decision that no other jury trials are going to take place while this one is going on. Although one judge managed to sneak one in, apparently.
Why would they do that?
Because it was such high profile and they had to bring in so many prospective jurors. That's what they said. That no other jury trials are going on while this one is going on. And so they have motion hearings and whatever, but no jury trials are going on while this one's going on. So like the judge is under a lot of pressure to like get this done, get it done quickly, and don't F it up.
When is she up for a re-election?
I don't know.
I have to count that in. Yeah.
Yeah,
But,
this is a really great case. If you land it and people are happy, then you're re-elected. But if she has to admit I made a boo boo and now it has to start over, she might be out of a job at the next election. So she will probably not admit to doing something stupid.
There's that problem too.
Needs to be in this trial.
Yeah.
Yeah, no, this is all kinds of a mess of a case, and the defense counsel isn't helping. But you get caught up in these things. So, what you were just saying, Kurt, though, if she files a motion to exclude this evidence, and the judge overrules her essentially in part, she can say then, doesn't she have a valid claim? Like, well, if the judge was going to allow part, then I'm allowed the other part in, even though I really don't think any of it should come in. You don't think that there's you think she's waiving that then?
I think the Court of Appeals could very well look at that as waiving it. Yeah.
But in the Young Thug trial, they had a similar last week where the judge put on the record that you don't waive the appeal issue because this is something the other part did.
It arguably, even if it doesn't waive the issue with respect to the portions that are already admitted, so even if it preserves that issue, because she would cross on it and the judge is like, well, I'm going to allow these other parts in, then presumably you could say the Court of Appeals is inviting that error because she's like, well, only because you asked did these other portions come in. So sure, the first parts are excluded, but the other exciting parts of the journal are let in, so we still don't care. There's any number of ways for the Court of Appeals to slice this to make the ruling that this is going to be maintained.
And you've seen the Court of Appeals work in this case specifically.
That would be one of the reasons that's driving me to that conclusion. Yeah, I think the Court of Appeals might be somewhat motivated to maintain a guilty verdict. Whatever would make me think of that? Well, geez, let's look at the evidence before us.
Michael Drum with the $4.99 super chat. Thank you. Do we know the dates of the journal entries? The page numbers are far apart. So to me, it seems like it could be a large gap between them. So the only date that's been identified during the preliminary examination, which is really when this came to light, was, I can't remember exactly. It was somewhere between November, I think it was November 27th or so, which would have been after they got the firearm, before the shooting, right in that couple of days. That seems to be the only time that the journal was really dated at all in any way, shape, or form. And there's been no evidence that the parents even saw it, even knew it existed. And of course, Ethan isn't talking, so we don't know. But the date puts it within that window. Thank you very much for the super chat, though. I don't want to make sure I didn't miss any others. I don't think so. So that's where we're at. We're just waiting for the court to come back. Are you streaming this too?
I'm hijacking your stream at the moment, so I'm just streaming this StreamYard thing. Enough. So I told you I hijacked your stream.
Joe did that yesterday.
They're going to go directly into lunch, right? It's almost 12.
And they might, yeah.
Yeah.
Well, if they break for lunch, I'm breaking for lunch.
Yeah, we might break for lunch, just depending on what's going on, or we might just continue it straight forward.
Unless we can find the exciting decision that somehow makes this all make sense from a legal perspective, because I'd love to have my mind blown.
Yeah,
I think if you stand up and run into your fridge a couple of times, it'll make sense after.
Uh-huh.
But
I ordered it. I don't know when it'll get here because the clerk's gotta send me an email with it, so it takes.
Oh, it's one of those courts. Oh, that's fun.
Yeah, you got to order it online, pay $1 per page or whatever, and then you eventually get it. All right, they're bringing her back in the courtroom.
Also, not for nothing, why do we have 7 different police officers on the side of the wall? Does that seem a little excessive to anyone else?
Yeah, it does. It does a little bit. Well, there's more outside in the hallway too, but the jury doesn't see that.
And again, she never did this to anyone, but they are treating her worse than Daryl Brooks. Brooks just had one
Yeah,
guy sitting behind him.
Yeah, I mean, I recently watched the Jeffrey Dahmer trial. There was only the bailiffs there, and that's Jeffrey
Yeah.
Dahmer.
Well, I will say that the Oakland County Sheriff act as bailiffs in this court, but there's definitely a lot more than they usually have, which is like one, maybe two.
Yeah.
Yeah, but at least they don't are not out on the street stopping cars for tinted windows.
And they want to look like a mass murderer, that's for sure.
Dave, I'm gonna jump off before it starts up again because I have
Okay.
stuff coming in. But
All right, take care, Baker. Everyone go subscribe to the Broken Baker. He's Danish. He's a Danish professional juror, but we don't hold it against him.
Professional.
And if someone
Kurt,
could
so
put a
nice
link-
to meet you. And Nick, we will be coming as soon as the ice settles. We will take back our country.
2279990
All right, take care, Baker.
Hey, Mark, keep some that people.
Here,
And she needs to put it up. Jennifer, oh, wait.
Okay, so I'm gonna have
Absolutely.
a couple questions for you. This is certainly one of the kind of things that you want to spend some time on. Initially, I want to point out that you have said you want a statement. However, I do not want to be caught, as that will make me getting the 9mm impossible. That's what you said you want. Okay, here's the problem with that. It might be a future plan, but this isn't a future plan not to get caught planning to shoot up the school. This is a future plan with regard to Jeffrey, right? Which is discussed
How is the other things not?
extensively prior to this, right? Jeffrey, Jeffrey would be the bird and the bird head,
Oh,
right? So.
Oh.
I see. Okay,
So there's,
that would
so,
open the door. Okay, I see what you're saying.
yeah, so.
Yeah, and of course I would ask,
I do not want to be caught, as that will make me getting the 9mm impossible. He's talking about getting caught with the bird head in a jar and the
Oh yeah, we don't want that
terrible
coming in.
things he did to baby birds. So I'm pretty sure that you do not want that to come in.
right, I don't want the baby birds to come in. I
Okay.
thought when he said I don't want to be caught, it was being caught like having mental problems.
It's the problem with not having the
being
declarant
bird, being
available.
caught with any of the stuff he's been doing.
Okay, well,
I didn't take it to be the bird, but I see what the court's saying.
if you.
And you're
if you
right, if
read-
that opens the door to the bird, then I don't want to open the door to the bird.
There's an extensive discussion prior to that with a picture, and about him dumping the bird's head in a bathroom, and
Is that on the same
We'll talk
page?
about it for the rest of the day because I want the attention. However, I do not want to be caught, as that will make me getting the 9mm impossible. He's not talking about getting caught with the plan to shoot up the school. He's talking
Okay,
about
I
getting
understand this
caught
part, sort of.
Putting the bird head in the bathroom and hurting the birds. So I think it's pretty safe to assume that you do not want that statement.
That's correct, Your Honor.
Okay.
All right, that I understand.
I know I'm going to regret this. I'm going to let you respond to this, but I also wonder, you say you want his statements. I have to find where my dad hid the 9mm, and I don't know where my dad hid it. It's hard for me to understand what that impeaches because we just saw a video where Mr. Crumbley is telling Mrs. Crumbley, she asks him specifically, where was the gun? And he says, I put it in the dresser, right?
That's the other gun. That's the other two guns.
Okay, but there's also statements to the police about where, isn't there a statement on the video to one of the police officers?
Yes, sir.
About where it was? Was that the armware one?
Yeah, where she hit the bullet struck.
Yeah, but
No,
this
she
is
put the bullets in the
the
drawer
Ethan's
of the
statement.
Yeah. Okay, well, isn't there other statements in this trial about where the SIG was?
Yes, Judge. And it's
Hid.
lots of different statements. That's part of their
Hidden,
part of the case.
It says it was
Where?
hidden.
okay?
Yeah.
All right, so anyway, the bird, Jeffrey's staying out of this.
Yeah, I agree
Okay.
with that.
All right.
And I misread that. I did not.
Okay, well, it's hard to read, so anyway, what else do you want to say about this?
Judge, this is the people's issue here, is that well over a year ago, this issue, as well as a number of other issues that have been addressed the last few days, have been settled. It was June 27th of 22. It was appealed. The application to the Court of Appeals was filed on July the 18th of 2022. this is a pattern now that appears to be part of council's strategy. That's fine.
At least we have a
But
date for the order,
people should
June
be
27th,
entitled to
2022.
Now prepare accordingly.
Sorry, what was that, Kurt?
Because he just said it was settled June 27th, 2022. Presumably that was the date of the order from the court on this issue.
I guess, but I'm not seeing it.
Okay.
Yeah, it's a
council has
appeals
promised
court. So it's
the Court of
note should be in
Appeals.
the
I'll take a Court of Appeals decision and maybe they'll explain it to me.
Yes.
Jury that Jennifer Crumbley is going to testify. That's significant because that entire Facebook thread has come in. That's over 2,000 pages. I know from my memory, there are a number of messages that will be very important at cross-examination. But because it's been sprung up mid-trial at the request for an unredacted copy of that, I want time to go through that before the defendant takes the stand so
What
I
was the
can
date?
have every passage ready.
I'm
June
sorry.
27th, 2022, I think is what I heard.
What?
The Facebook thread
The
between
Facebook, okay.
Jennifer and James Crumbley.
Okay.
Your
chat.
Honor,
Do you catch the date?
prosecution moved to admit the whole thing. I have no objection. I'm ready to go with it.
Okay.
They moved to admit the whole
Okay,
thing
wait.
in front of the jury. Now he's saying he's not ready for
Wait a
it.
minute, am I missing something? I'm talking about the journal right now.
Yes, this is the pattern, Judge, the pattern of strategy. And again, counsel's entitled to her own strategy.
Right.
However, we are entitled to prepare our witnesses accordingly, including the cross-examination of the defense witnesses.
It's
We
your case
responded
state.
to the defendant's motions with the journal in particular with a select number of passages that firmly fit within the instructions provided by this court.
And that was in response to her motion. wasn't it?
Yes, Judge.
The
and
state has
it's
had the
court's
discovery
order, not
for
the
longer than
defendant's
the
order.
defense.
So we're following
You're
the
not
court's
prepared,
order when we
not an
prepare
excuse.
trial. Again, if counsel
Shit,
wants
really?
to reverse course mid-trial as part of our strategy, that's her decision. But we
He's
need
trying to
have
make,
time to prepare.
His problem,
So I'm
that's
asking
their
for the
problem.
court to give us the time to go through that Facebook thread, as the court gave defense counsel time to go through statements of her clients, her own
How-
client statements.
how
before Mr.
does-
Lowe's testified.
Reading this portion of the
Oh,
diary,
yeah,
open
you
up a
guys,
2,000
um,
page
I'm gonna
Facebook
finish
thread?
Off into Never Land here.
Question
I want
mark?
to address the journal and then finish the lieutenant's testimony. I also want to make the sealed record during the time period that the jury is eating lunch. So at this moment.
A sealed record. That's exciting for both
I'm
of
going
us.
to indicate that I am very concerned about the journal. The journal is extremely disturbing in many, many, many ways. And I do not want to risk the door being opened. But more importantly, these statements, I have to find where my dad hid the 9mm and where, I don't know where my dad hid it. I don't know if that it impeaches anything in this case, because there's already been plenty of evidence that he found it, right? There's evidence, the shooter found the
Yeah,
gun,
but
right? And there.
he's
have been
not on
statements
trial.
made,
Jennifer is
by
on
both
trial.
the defendant and her husband to.
This is about her
in
knowledge.
text, whatever it is, indicating that the gun was hidden in some way, obviously very poorly. But the gun was hidden in some way. The gun, as far as we know, was not sitting on the kitchen table. So I don't think this impeaches anything. I don't think it's contradictory. More importantly, I don't think under any circumstances, any more of this journal should come in. And in the event that it was going to come in, I think that it should have been handled prior to the jury trial. I am trying to very much protect any potential appellate record, and I do not want to delve into this journal. I think that would do nothing more than hurt Mrs. Crumbley severely. It's highly prejudicial. So that's my ruling about the journal.
If the journal
I don't think
is
the, I don't
like
think the
this-
contents of the journal matter because you have to prove
I
this.
appreciate if we did that when the jury's at lunch after we get the.
And you already let parts of the journal in,
Okay,
so
let's finish it, okay?
I don't know. What are your thoughts, Kurt?
I'm confused.
this is strange.
Okay,
Yeah.
the lunch arrived, so they.
You already, the rest,
So the judge basically
the pro-
denied those two portions of the journal coming in.
yeah, but I don't understand why, because if that opens the door to the rest of the journal, why doesn't all the prosecution's part that they awarded it, why don't,
You can sit down.
Ah,
You can sit down.
you have the rule of completion, the right to impeach.
Both.
I mean, there's so much,
Well, I think I sent, had my assistant send it in. Yes, yeah.
So are they
think
done
this
with
is to
cross?
send an early morning, email
I don't know what even is happening
about
at this
making a
point.
sealed record pursuant to Michigan Rule 8.119.
Yeah.
Yes.
Only the state gets to cherry pick.
Yes.
All right, so, because of that, I'm going to, exclude everyone, but parties. We're going to do that briefly, then I'm going to allow Ms. Crumbley to go downstairs and eat her lunch, and we're gonna break until 12:30.
Just
Right.
before
We're
we
breaking
go off the
this.
record, I just wanted
Okay.
to complete the record that we were speaking.
Okay, go ahead.
So, we've gone through this. I don't want to belabor the point. The issue that the people have is that it appears that council is trying to usurp the court's order without notice to the people. And that makes it impossible.
Okay, start over with this issue, because I was talking about the journal, and then you
Yes,
started
Judge,
telling me,
it's-
so start over, okay?
Thank you, Judge. The journal appears to be a pattern of strategy, which is without notice, mid-witness, shifting from what the court has
What do you
already
mean
ordered
without
to
notice?
what council chooses to be convenient. And again, if that's trial strategy, that's trial strategy, but we have the court's order, not the defendant's order. And I don't believe it is appropriate for any party to usurp a court's order. And I also don't think it's appropriate that the people will have to respond off the cuff. I want to make sure that our witnesses are prepared.
Okay.
I want to make sure the materials necessary for cross-examination are prepared as well.
Okay,
So
so the issue
prepared.
right now is the numerous Facebook communications between, Mrs. Crumbley and Mr. Crumbley. That's the issue,
that's,
that came in.
And Your
that's
Honor,
the piece of evidence.
Okay.
Within that piece of evidence, there are a number of issues to explore.
Okay,
Within that piece of evidence, it includes items that defense counsel had previously sought to exclude, and this court did in fact exclude. So that was the discussion that we had when Mrs. Crumbley was placed on the record, and she said under oath that it was her decision upon consultation with her attorney, knowing that we could cross-examine. I just want to make sure that people are given the opportunity to review all of those 2,000 messages or 2,000 pages of messages appropriately before that cross-examination begins.
Your Honor, I just want to point out that the prosecution moved to admit the entire thing in front of the jury. So I believe if I objected, it would look like Mrs. Crumbley is hiding materials. And we've taken the trial strategy actually based on their trial strategy, bring it all in.
okay.
And so when Mr. Keys
It was a
did,
redacted copy.
Okay, I don't
But listen,
understand, I don't
when-
understand why we're,
He's-
taking a trip down memory lane. The whole thing came in already.
right, it came in, but I'm saying he asked for it. That was days ago. And I'll tell you what,
And then you agreed to it.
I did. And since that time, I've read the whole thing and I'm ready to go with it. What
Okay.
he's saying is that he's not ready to go with it, even though he moved to admit it. And even though it was days ago that he moved to
Just
admit
to
it.
correct the record, we moved for a redacted copy and for counsel to specify exactly what portions were redacted in accordance with your order,
And
Judge.
the next day I got back to them, which was days
I'm
ago,
gonna ask
and
you to
I
keep your
said,
voice down because the walls are paper thin and the jury can hear you.
I got back to them the day after and I said, we're not asking for any redactions. They said, fine. We made a record with Mrs. Crumbley, no
Okay,
redactions.
when is this gonna come up anyway? How far are we gonna get after Lieutenant Willis?
I guess it depends on how often this comes up. And this is why I bring it to the court's attention that
This will come up when Mrs. Crumbley testifies if she does, right?
certainly,
Okay, is that the only time?
well, I brought up the pattern to the court's attention because it does appear to be a pattern. The only reason I bring it to the court's attention now and our objection to that is because it appears to be a continual theme. So I want to bring it to the court's attention now, and I want a record made of it. That's why I bring it up now.
Okay, well, you can't admit something and then unadmit something. There's no court rule that says you can do that, right? Okay.
No, it's the redacted portions, it's the portions within that would have been inadmissible prior to,
Yeah, I get it.
okay.
Yeah,
And we said we still.
We're letting it all hang out.
We're letting it all hang out.
okay.
I don't want any redactions.
Letting it all
because I
hang
think
out.
it makes it, Mr. Keys just made it look like if we put redactions in there, we're hiding stuff.
I
So
don't
I'm
even know
not,
why we're talking about this.
we
The
shouldn't
whole
be.
record came in. It is in evidence. It is fair game, okay? All right, that's what we're doing.
With respect to the sealed record, I just like to rely on my written pleadings.
Okay, well, you probably are, but I'm going to make a record of those because privilege.
There are sealed pleadings
Conversations between the shooter
and sealed
Yeah, I think they're
decisions. Is that
regarding-
what we're doing?
Yeah, it's regarding Ethan, I'm pretty sure.
and,
Okay, so we have no idea what's going on because everything's sealed. That's great. That's very helpful.
Yeah.
This legal education is brought to you by nobody because no one can talk about what's going on because we have no idea.
throwing everybody out.
Yeah, they're going to toss everyone out except for the parties and address something on a sealed record, probably having to
This
do
will
with
be
the
on the
minor and his
Oh, yeah.
mental health records, most likely. But we have no idea because we're going to find out. There was a motion before trial to admit Ethan's medical records that were used during his Miller hearing, and those were granted. But those were also granted at the time when Ethan was going to testify. So now I think there's a privilege argument. I think Ethan's counsel is now here to argue because they filed an interpleader to exclude his medical records as well as to impose the Fifth Amendment. And I have a feeling that's what's going to be argued right now. Just looking at the court record, there was a bunch of interpleader filings and responses to those. So that's most likely what's going to be argued right now, not off the record, on the record, but so that we can't see, because he's technically still a juvenile.
Is he?
Yeah, he's only 17.
Even though
He
he's
hasn't been
tried as an adult,
emancipated.
so we get it both ways.
Get
Yep.
it both ways. Yep.
Oh, that's
And so everyone in my chat, or not everyone, but a lot of people are like, well, how is he tried as an adult and still holding the parents accountable? The trying of it as an adult in Michigan just says that instead of going into the juvenile, we're going to try to redirect him sort of approach, we're going into the punishment approach for this violation of law. And it's an option if the juvenile commits anything that would amount to a felony. So they can still charge him as a juvenile and sort of redirect him with therapy and counseling.
I agree with the confusion of the chat. I understand the principle that we're going to charge him as an adult, but as the judge said earlier on different issues, like you can't have this both ways at the same time. If he's an adult, then he's an adult.
Yeah.
Well, get this. So the prosecution argued during the Miller hearing that this was 100% on Ethan and that his parents essentially were not to blame when it comes to Ethan's punishment. And now they're arguing contradictory to that in this case. That's partly why I wanted to watch the Miller hearings, to see what their arguments, their position was going to be.
I wish they could take that in as an admission from the prosecution.
Is there some sort of collateral estoppel issue in there where you can argue the prosecutor can't argue both because collateral estoppel?
I was going to look into it and I never did, but I would hope that the defense counsel would argue that, but they I never saw it come in as an argument in a motion or anything. So. No, I would imagine it would be a collateral estoppel issue, but I never researched it under Michigan law. So
yeah, I mean, it's the same fundamental thing. You can't argue both things at the same time. Once you've argued one, you're stuck with it. And this is a collateral proceeding. I mean, it's related to the same underlying facts. So I view it as collateral, and therefore you're stopped. You can't take position 1 minute and then take exactly the opposite position the next.
And it's the exact same two prosecutors too. It's not even like it's different prosecutors out of, if you want to make an argument about that, the representation, whatever, but still at the end of the day, it's the same party. It's the state.
Right. The prosecutors are irrelevant, but to the extent it's relevant, then you got that too. Yeah.
Yeah. What is the reason for having a different judge at the preliminary hearing? So a preliminary hearing is at the district court level. When you're being charged with a felony, the local city court kind of thing determines whether or not there's probable cause that there's been a felony and that the defendants are the ones that committed it. And then you get bound up to circuit court, which is where we're at now, who will actually hear the case. So that's how that works, because we don't really use grand juries in Michigan. So that's the procedure that we have.
Okay.
Please explain how Jennifer Crumbley was charged as an adult when she acted like a petulant child.
That's funny.
I like that. That's a good one.
Yeah, but two different counts, yes, but one is dependent on the other.
Yeah. I mean, it is technically different parties, but still, I mean, it's still the underlying same event. I feel like there's got to be something in there somewhere.
I feel like that too. And then as I was kind of balancing it out, I'm like, well, parties are allowed to plead in the alternative, even in criminal cases. So
in some states they are. Are they in Michigan?
Yeah, you can.
So they were actually arguing both at the same time, and therefore it's not stopped. I love it.
Yeah,
Okay, that's
Yeah,
good.
So
All right.
yeah, so that's allowed too. And I was just kind of like puzzling it out in my mind. I didn't do any of the research though. That I probably should.
So yeah, so they were in the prior case saying Ethan is completely responsible. Also, Ethan is not completely responsible, and you can argue both, even though they're mutually inconsistent. Love it.
Yeah, yeah.
That the feds
Yep,
the feds
yep.
allow that. The feds allow that too. Mutually inconsistent pleading. Yeah, it's this and also not this at the same time.
Yeah, isn't it nice?
Yeah.
Well, we had an issue with that Georgia Supreme Court with inconsistent positions on like insanity and not insane at the same time, committing the exact same act that resulted in 2 different crimes.
Yeah.
Yeah.
Somehow, yeah, that makes sense. I'm not sure how it makes sense, but okay. I mean, I understand how, at least hypothetically, you could be insane in one moment and not the next. So if there's any difference in the crime or any difference in time, I mean, hypothetically, you could split the difference. But if it's literally the same exact event, it's a little bit hard to say how you can be insane for one and not the other. But I remember reading that Court of Appeals decision too, and they're apparently okay with it, so no problem. Although I suppose in some ways it does parallel the Supreme Court's decision when it comes back to the idea of mutually inconsistent verdicts generally, because the feds have dealt with this before. The most obvious example I can think of is when it comes to felony murder. So, for example, felony murder is the death that occurs during a felony, usually an inherently dangerous felony. So the convenience store robbery is a classic example, right? We're going to go rob the convenience store. Someone pulls out a gun. Someone dies. Felony murder. So logically, you need conviction on the underlying felony for it to be felony murder, because that's the thing. But it has been known to happen occasionally where the jury will say, no, there wasn't the underlying felony, but yes, felony murder. And even though that doesn't make any logical sense, the Supreme Court of the United States in such situations said, yeah, we're good. No problem. That's fine. Because we don't know what the jury was thinking. We don't know if it was a compromise. We don't know if they were trying, we don't know which is inconsistent with the other. So we don't know what to do. And so it's fine. No problem. It's all good. The law's a strange place sometimes.
Yeah, I just don't understand how. I mean, I get the idea in civil cases, certain civil cases, like say unjust enrichment and conversion, where you're like, okay, it's essentially 2 sides of the same coin, different theories, where somebody stole money from you, and as a result, they were unjustly enriched, right? I get that with certain civil things, but not in this sort of context. Either you did this or you didn't do that,
Uh-huh.
Can the defense call the doctor that assessed Ethan's mental health? That might be actually what they're arguing over right now, because there's a big thing regarding the mental health issue. So, but we don't know.
Yeah. Okay. I'm very confused. But then the law doesn't always make sense to me. The law is a strange place.
Well, it's hard for the law when they're trying to create new law in the midst of a trial.
That too. Yeah, we're literally trying to create a brand new criminal cause of action before our eyes. That's fun too. That's good.
Yeah, they're just kind of throwing everything up in the air and hoping that it lands, or at least the state's hoping that it lands on their side.
Yeah, I asked I had a Twitter poll the other day where I asked, would it be the same if Ethan had used a car or a knife or a frying pan? Why is it important that he used a gun if the end result is the same?
And sort of backwards from there, which is where I've sort of raised the issue, because we live in a common law system in the United States. This is a brick in a wall, and where does it go next is always a relevant question in the United States. It's not so much slippery slope isn't so much a fallacy as a reality in the common law system, because things never really stop. And so where does this go with respect to other crimes and other parents, particularly, by the way, because parents do have an affirmative duty with respect to their children. They do have an affirmative obligation to clothe them and feed them and keep them warm and all kinds of stuff. So hypothetically, you could charge a parent for not doing things that caused the child to commit a crime. So just as a random hypothetical, if you had a parent who knew their kid was in a gang, for example, then now they didn't do anything to support it, but they knew it. And maybe they knew, for example, their kid dealt drugs and knew that there's drugs in the house or guns in the house or whatever it is. Maybe the failure to act is sufficient. Maybe the failure, even if they don't know those things are in the house, maybe the very fact that the kid is in a gang and that would inevitably lead to violence, maybe the failure of the parent to take steps to prevent him from being in the gang any further. Maybe that's sufficient. And I raise so it raises all kinds of fun and exciting questions. And this is where my prognostication powers run out, because although I like to think I'm reasonably intelligent, I can't foresee all ends. And this is where it's like, I don't know what happens next.
There are so many unknown ends as a result of this conviction if it happens. Like you just said. And the problem I have is that what you're setting up is, so within this theory, right? First, they would have had to have known that there was an issue. Let's assume they knew that there was an issue, right? There was a danger out there. Their child posed a danger, and then failed to take reasonable steps to prevent it. Okay, what does that look like? Is that getting him counseling? Is that pulling him out of school for that one day, and then he goes back the next day and does it, right? We assume that the crime happens at some point. The shooting happens somewhere down the road. So they get him counseling. Well, do they get him enough counseling? Is he going as often as he should? Is he getting medication? Did they forego medication, which is a parent's right, in lieu of alternative therapy and things like that? Essentially, what you're setting up is the state can say, after the fact, mind you, you didn't do enough. We're not going to tell you what you need to do ahead of time, but after the fact, we're going to say you didn't do enough.
You're basically winding up into a strict liability universe. The bad thing happened, therefore you're responsible. Don't you know it's inherently dangerous to have children? Lol.
Yeah,
well,
and which is interesting, because this court ruled that you can't have the hearing that we listened to about what do you call it? The pathway to violence. It's inadmissible, but that's the prosecution's theory here, that the parents should have known that Ethan was on a pathway to this.
It's actually slightly worse than that. It's slightly worse than that if you take the Court of Appeals at its word, because what the Court of Appeals literally wrote was that it was reasonably foreseeable that the parents could have foreseen that Ethan was going to commit a shooting on that day. So apparently what the Court of Appeals thinks is foreseeable is he was going to shoot people on that particular day. And to me, that seems like an awful lot of foresight.
Yeah.
They said it twice. They said it twice, by the way, in that opinion, just for the record.
But so we have the foreseeability part, right? Which is the known part, right? But then you still have to take reasonable care. So you're talking about an hour and a half to 2 hours. What's the reasonable care that could have taken place within that 2 hour window that would have alleviated this criminal liability? Colorado may as well. Wait, what is this? Thank you for the $1.99 super chat.
And also, somewhat relatedly, how many warning signs do you need as we're trying to split the difference between the school and the parents? Just how many warning signs do you need before you have some obligation to foresee?
Right.
Yeah, and they have the school counselor up there saying, okay, you have to go to work. No problem. We can keep him in school. But they're not liable criminally because they have immunity or whatever it was.
Well, they couldn't foresee it because they couldn't foresee it because they didn't know enough. If they'd only known more, when the parents knew enough. So I suppose the question is, assuming both those things are true at the same time, which I'm not even sure is a premise I grant, but let's play. Where's the line in between? Where's the line in between? How much do you need to know before you're liable? If what the school knows isn't enough, just how much more additional things do you need to know?
Yeah, and if a school counselor and the other person says, well, are you as a parent, are you supposed to, okay, they must be lying. Or do you believe them on their word? And because they have this absolute defense in, it doesn't matter, we're immune for criminal liability. Or no, civil liability. And the prosecution won't charge the school or the counselors.
Yep.
Because it's the parents' fault for listening to the counselors.
Apparently.
I am shout with the $5 super chat. It becomes the end of society because it leads people to stop having kids. No one wants to be charged with another's crime. There's still going to be people out there having kids, unfortunately, but they're going to be the type of people that would get committed or get convicted for other people's crimes. But it leads the intelligent people to not have kids. That's for sure. I say homeschool them. That's the key.
Well, that's criminal because you failed to get your child sufficient socialization. That's why he acted out criminally and shot up the park.
Oh,
Don't you know?
right. Yeah, damn it.
Yeah.
But it goes beyond, like somebody said.
You tell me what the reasonable steps are. You tell me what the reasonable steps are, and I'll play prosecutor and tell you why it's not reasonable.
Well, someone said lock up all your guns was like rule number 1. Okay, so the kid takes the kitchen knife. Now what? Is the parent responsible? They didn't lock up their kitchen knives.
Yeah, but he took the car keys and plowed into a mall.
Yeah.
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 So yeah, no, all of this is absolutely ridiculous. Homeschooling does not equal no socialization. That's true as a fundamental rule, but we can't know for certain that you got enough socialization if you're homeschooled because you're not out.
Hey, I'm the prosecutor. I say it's no socialization. You prove the opposite. That'd be good. Yeah, go with that. Let me know how it works out.
What a mess. Let's see here. Sorry, I'm just pulling. I'm just to see.
Do you know where your children are? I mean, every decision can be looked guilty in retrospect, and we've seen prosecutors do exactly that with a lot of things. Oh, you used Full Metal Jacket. Of course, that was reckless because you wanted the bullets to overpenetrate. Oh, you used jacketed hollow point. Of course, that's reckless. You wanted to cause maximum damage. Oh, you loaded your own ammo. Well, that shows foresight to commit murder because you were planning it all along, don't you know? Oh, you did. No, there is no right decision. This is what you guys don't seem to understand or appreciate. And there's any number of prosecutors that do this. Oh, you killed this person, after a long period of cooling off. That shows how cold-blooded you are. Oh, you killed this person immediately. That shows just how violently tempered you are. There is no right decision. Everything will be held against you. There is no right answer.
No.
Everything's screwed.
Oh,
you're done.
Oh, you as a parent, you like wearing camouflaged cargo pants?
Yeah.
That means that you're teaching your kids how to hide.
Yeah, that's right. Give me a couple minutes. I'll figure out how not buying them.
Know to go to read.
Yeah. Give me a couple minutes. I'll figure out how not buying them camo is a sign of recklessness.
We don't even need to go that far. In this case alone, for the whole fleeing thing, the witness, the police officer witness said, yes, I told James and Jennifer, first of all, they didn't want to give up their phones because they didn't have the phone number. So I gave them a pen and paper. They could write them down. And then they happily gave up their phones on the warrant. And then I told them to go buy burner phones as an alternative, a track phone or whatever.
Right. And then they did that, and that makes them more guilty.
Exactly. That makes them more guilty. Yep. And the prosecutor's next witness, well, they had these track phones. They must have been on the run. It's just, there's nothing you could say to the police. There's nothing that you don't have to say to the police. They're going to use all of your normal things against you.
Well, as always, as ever, I will continue to remind you the mantra, I want to remain silent. I want a lawyer. Because the MLS is not wrong. They're going to use everything else, every other possible way. But why give them one more things? In particular, by the way, of course, words from your own mouth are juries eat that shit up. So you say it from your own mouth, you're toast. So it may be true that this is not like keep your mouth shut, therefore you won't go to prison. I'm not saying that. I am saying open your mouth, you're going to prison. So keep your mouth shut and hope for the best.
That's exactly right.
Yeah,
the court is still
yeah, well, they're on break. They're on break for 40 minutes. They're on lunch now.
Yeah.
Oh, okay.
And it's always easy for another part to say these people to say, no, you did wrong. An example, what was it? San Francisco said, "Oh, we are what do you call it?
Sanctuary city."
Yeah. Okay, said the other states and started busing people there. Oh no! You
not like that. Yeah, I do like New York and Chicago being like not like that, and they're trying to sue people for sending people them that way. It's like, but they won't admit they're wrong. They won't just say we were wrong. So that's hilarious.
Kurt, I wanted to ask you, did you see the part where they were basically saying Jennifer refused to ask questions until she was with an attorney? They talked about that in this case. Don't you believe that it'd be a violation of her Sixth Amendment right?
Well, I don't know for sure because I thought on the portion I saw, she phrased it as a question. She said something like, "Don't you think I should get a lawyer?" or something like that. I don't think she said. I think I think James Crumbley said it more definitively, but I thought that Jennifer Crumbley stated it more ambiguously. Am I wrong about that?
It wasn't the police interrogation part. It was in the police car, I believe. I might be wrong though. My mind's a blur in this case.
And it would also depend, of course, if she kept saying things after that, because you have to actually, when you want the right to remain silent, you have to do that. Because if you start volunteering things again, yeah, that's a real problem.
Yeah.
So she might have said, "I want a lawyer," and then kept talking, and that doesn't work either. Yeah.
Yeah. In my opinion, as long as if you say the word lawyer, and as long as you don't say "I do not want a lawyer," then you should have a lawyer, no matter how it's phrased.
I'm not saying you're wrong. I'm just saying that's not the law in the U.S. Apparently, it is the law in Canada. Apparently, any ambiguity, the police do have an affirmative duty to clear up. So that's nice for Canada, but welcome to the USA. What can I tell you?
I thought Canada too also you had to make a affirmative statement of some sort. I thought I heard on one of Ethan's streams recently.
Yeah, you have to make. Yeah, I think you do have to make an affirmative statement, but you're not allowed a lawyer in the room no matter what you say, which is kind of funny. So that's fun. So you can talk to a lawyer, they just can't be in the room with you. So you go consult a lawyer, and then you come back and you open your mouth. So that's great.
Can you bring in the piece of paper that your lawyer wrote out for you? Say this and only this.
Just hold up the sign. Just hold up the sign.
Exactly. Yeah.
Yeah. Tape it right to your forehead.
I don't remember the phrase "I want a lawyer, dog."
No. That case was wildly misreported. The lawyer dog case was wildly misreported. If you actually go to the judge's decision, see what he said, it wasn't about the lawyer dog. It was because he asked it as a question. What he actually said is, I'm going to paraphrase it, but I'm going to get pretty close. He said, "If you all think I'm guilty, then maybe I should get a lawyer dog." And that's not a request. That was the basis of the judge's decision. He didn't actually say, "I want a lawyer dog." He said, "Maybe I should get a lawyer dog," and that doesn't count.
See, that's the same thing that Zach Anderson ran into. And now, first of all, he talked for an hour before he even mentioned the word lawyer, but he was like, either take me home or get me a lawyer. He gave him an option. And they kept asking him questions. And he was like, "All right, I want a lawyer now." And then
there you go. Exactly. But
it took him an hour and a half to get there, unfortunately.
Just all you have to do is state it. But any ambiguity, do you think I should get a lawyer? Is it a good idea if I get a lawyer? What do you think? Is a lawyer nice? Lawyer? Like any sort of ambiguity, the Supreme Court's gonna. That's what I say.
Forward.
That's what I say. I tell my channel all the time. Meditate to it. Use it as your mantra in meditation. I want a lawyer. I want to remain silent. Just that, only that. Don't alter it. Don't say other words. Don't add words. Just that, please. That'd be great. And if you feel that urge deep inside that you feel like you need to say something, just say it again. Just repeat it. Your future lawyer thanks you.
And don't even phrase it as "I want a lawyer," because that can be construed as a question.
No.
I want a lawyer.
Yeah. No.
Somebody said that Jennifer wanted to homeschool because she didn't want to spend much time with her kid. Let's assume she doesn't want to spend that much time with her kid. Kurt, have you heard any evidence in this trial? I don't know how much you've watched, but
I've watched it all.
Okay. Is there any evidence that one, she knew, and two, she failed to take corrective steps?
Not as much as I would like. No, not really. No, there really is no great evidence that she knew because we have statements that really don't go to that level of depth. There's really not sufficient information, in my humble opinion. But
now,
don't depend on the Court of Appeals saying that. Oh yeah,
no, that's true.
No, absolutely. The defense's burden is to prove innocence. No doubt.
That's my thought. And that's why she has to take the stand. Not only because it was mentioned in opening statements, which, by the way, please never do that. Please never say that your defendant is going to take the stand.
Yeah, that's really not a great idea.
But now she has to take the stand. Not only because of that, but I feel like, and sitting through jury voir dire, I even thought the same thing. Just where the Q&A was going back and forth with the judge and the attorneys and the jurors. I was like, this woman's going to have to take the stand. Okay, so Robbie with a $9.99 super chat. Thank you. Do not discuss your day. Do not provide any information beyond your name, address, etc., etc. Ask if you're detained or able to go free. If free to go, leave. If detained, ask for a lawyer and shut up. Not legal advice, but that's pretty good.
I generally agree that you should give your name, notwithstanding any law to the contrary, because you'd give anyone your name. So why not? I mean, if any random person said, "What's your name?" I presume you would tell them. So why not tell the police? Because what does it matter? And yeah, and other than that, I tend to agree. Yeah.
Yeah, generally, if somebody asks me for my name, I really want them to state theirs first.
Well, this statement, by the way, is do not provide any information beyond your name and your address. So
I understood that. I agree.
Yeah, okay.
Name, address, date of birth is fine. Yeah.
Love the panel. Thank you very much for the 2001. I'm assuming that's one, right?
Richard W. in chat. Richard W. in chat literally says, "I don't tell strangers my name." Richard W., I have bad news for you. You told me your name.
KPM wants to know if you do probate cases for some reason.
No.
I didn't think so. You do mainly appellate stuff, right?
My practice in the past has been patent law, intellectual property. At the moment, I'm on hiatus, but my love is appellate law. So yeah. Okay. All right, we've got a half hour. I'm going to use this half hour to go eat lunch. So I'm going to sign off for now. But I've enjoyed talking with you, and maybe I'll pop in later. So does the link you sent me earlier still work for this afternoon?
Yeah. I'm just going to keep it going. I set up an afternoon stream, but I don't think I'm going to kill it. So
all right, great. Well, I'll talk to you guys later. Love you lots.
All right, take care. Thanks, Kurt.
All right, bye. All right, well, that was fun, everyone. We had a good time where we had some interesting discussion about what exactly the law is, and we all wound up really confused. So I hope you like that. I like that. It was a spontaneous thing, and it was a fun discussion because I was like, I need help, and like, let's go to MLS. He's a lawyer. Let's see if he understands this. Help me. And he's like, I don't know what's going on either. I'm like, oh, okay. So it's not just me. It's like, I need a second opinion. Do you understand what's going on? Nope. Oh, okay. Yeah. So that was fun. I appreciate that. Yeah. Yeah. Maybe Richard W. is a burner name. Well, either way, I made my point. So even if he's in chat, like, no, that's a burner name. It's like, I made my point. So, yeah. Yeah. What's the channel name for that? It's MLS. It is Making Law Simple. Making Law Simple is the name of the channel. If you want to go check that out. He only has 5,000 subscribers. He could use a like. Yeah. I don't pretend to know every law. I don't pretend to understand everything. And when I don't understand something, I'm like, let me go to another expert. Maybe they can explain the thing to me. And when the other expert's like, I don't understand it either, I'm like, oh, okay, we're all confused. We're all confused. Yeah. All right, guys, I have a half hour. I'm going to use this time to go get some food. Hopefully, Paralegal Liz will join us this afternoon. That will be fun. And we'll talk some more. I'll see you guys in about half hour. Until then, my friends, I've been Uncivil Law. I hope you have a great one. Keep it safe out there. Until later, my friends. Goodbye.